Okay, good morning, everybody. I have 9 o'clock on my phone, which is our scheduled start time. Madam Court Reporter, are we ready to begin?
Yes, Mr. Hearing Examiner.
Thank you. Good morning, everybody. We are here for a hearing in case number 2300252 UT in the matter of Southwestern Public Service Company's application requesting issuance of a certificate of public convenience and necessity to construct and operate solar generation and battery storage projects and associated facilities, authorization of related rate-making principles, including accrual of an allowance for funds used during construction, authorization to abandon the Cunningham Unit 2 generating facility, and other associated relief. Today is Monday, February 12th, 2024. My name is Hans Muller. I will be the hearing examiner to preside over today's hearing. Let's go ahead and enter appearances, starting with SPS.
Good morning, Mr. Examiner. Dana Hardy with the Santa Fe office of Hinkle Shaner on behalf of SPS. And also appearing for SPS will be Ms. Andrea Stover, Mr. Patrick Leahy, and Mr. Landon Lill. However, only one of us will actively participate at a time.
Thank you.
Thank you.
Occidental Permian.
Good morning, Your Honor. Michael McMillan for Occidental Permian Limited.
Good morning, Michael. New Mexico Large Customer Group.
Good morning, Your Honor. Nick Stoffel with the law firm of Holland and Hart, appearing on behalf of the New Mexico Large Customer Group. I'd also like to enter the appearance of my colleague, Austin Rushoff.
Good morning to you both.
Your Honor, if I may cut in briefly, I apologize. My computer just informed me that it is restarting, and I can't do anything about that, so I will be right back, hopefully very quickly.
Thank you for the heads up. Louisiana Energy Services.
Good morning. This is Joan Drake with Module Sperling on behalf of Louisiana Energy Services, or LES. And with me today and tomorrow will be Susan Miller, but only one of us will appear on the Zoom.
Okay, thank you.
Thanks.
Let's see. The artist formerly known as the New Mexico Office of the Attorney General, now known as the Department of Justice.
Good morning, Your Honor. This is Jocelyn Barrett appearing on behalf of the New Mexico Department of Justice.
Good morning.
Good morning.
Coalition for Clean Affordable Energy. And hearing nothing, and I do not see Miss Lynch as a current participant, we will note that CCAE is currently absent. And staff of the Commission's Utility Division.
Good morning, Mr. Hearing Examiner. John Bagacco, appearing for the NMPRC Utility Division staff. And I have as backup Mr. Ryan Friedman. But I think I'm going to probably handle this one myself unless I get hit by a bus.
Hopefully that doesn't happen, John. All right. There is one official transcript of this proceeding, and that is the transcript produced by our court reporter. She will supply that transcript to the commission, and it will be maintained on eDocket. It is the only official transcript. No party is authorized to record this proceeding. Exhibits. Our court reporter will also collect exhibits from the parties and transmit them to the commission as the official record of exhibits admitted during this hearing. I gave you directions about exchanging exhibits using Dropbox. And SPS entered exhibits 1 through 10. OPL entered exhibits 1 through 12. NMLCG with exhibits 1 through 11. LES had exhibit 1. Department of Justice exhibits 1 through 6. And staff had exhibits 1 through 5, so everyone was able to load their information into Dropbox. As I mentioned, it looks like CCAE currently has not appeared. We will go for an hour and a half this morning and then take a 10-minute break. Lunch will be from noon to 1, and we will wrap up today at 5 o'clock. We will not go to overtime like last night's Super Bowl. To the extent that this in any way interferes with completing work, we will have another day of hearing. This is principally for our court reporter so that she has time to reset during the day. Madam Court Reporter, you feel free to interject at any time and direct people to slow down or adjust their audio so that you can hear accordingly for the transcript. The presentation of evidence in this case would follow 1.2.2.33b, applications and petitions. And we have already established the order of witnesses for today. For SPS, we will start with Ms. Trammell. And then this afternoon, we will have witnesses Elsie, Cooley, Littall, Fetters, and Bornhofen. And we have established, the parties have previously established the order of cross-examination and requested the times. The Commission's initial order in this matter vested the hearing examiners with authority to conduct any necessary hearings and to take any other actions consistent with Commission procedure. Under Section 62-6-4 NMSA 1978, the Commission, and by extension through the delegation of powers, the hearing examiners also exercise broad power to supervise and regulate utilities in order to protect utility ratepayers and ensure that the utility provides reasonable and proper service at fair, just, and reasonable rates. To the extent that the hearing examiner asks additional inquiries during this proceeding, is consistent with the delegation of that authority and practice of the Commission. Scope of redirect today is matters arising from cross-examination or questioning by the hearing examiner. Recross is at the discretion of the hearing examiner and will be limited to matters arising from redirect. Basic import of these rules is to ensure orderly questioning today. I have not been informed of anyone who signed up for public comment today. And let's do a little housekeeping here first. Let's start with the classified information. There is a revised motion for protection. So Ms. Hardy, I think we had initially said at the pre-hearing that some of OPL's exhibits were public, but it looks like we are revising that. Can you clarify that for me?
Yes, that's correct, Mr. Examiner. We have determined that the information included in Mr. Lai's testimony at pages 9 and 10, which OPL marked as confidential, should be accorded confidential treatment, along with Mr. Lai's work papers. He has one set of confidential work papers that are included in exhibit OPL 1C. So we did file a request and supporting affidavit seeking confidential treatment of those items.
Okay. So let me just deal with the motion at hand then. Are there any objections to the motion at hand for the protection of the confidential matter filed by SPS?
Your Honor, no objection from the NMLCG. I note Mr. McMillan does not appear to have returned to the Zoom room yet.
Yeah, I do not have anyone in the waiting room either. I think for purposes, obviously I'll grant the request. What I'd like OPL to do then for ease of our court reporter is to file an amended direct testimony redacting what is itemized in this motion on pages 9 and 10 of Mr. Lai's direct testimony and what is pointed out on his analysis of his work papers. I think it would be easier for our court reporter if we just submitted a redacted version of that, noting it as redacted. So I will not enter, I'll get to that in a minute. I'm not going to enter that testimony onto the record today. I'm going to do this day by day. But just for ease of which exhibit our court reporter should have access to file with the transcript, I'd like a redacted version. Is that acceptable?
That's fine with SPS, Mr. Examiner.
Okay.
I believe that OPL did file a redacted version, but
Let
would need
me,
Mr. McMillan to confirm.
yeah, let me check what is on there while we're waiting for him to get back on here. There he is.
Okay, after that very well-timed break, I should be back. I will let you know if it tries to force me off again.
Okay, thank you. We're actually right you're right on cue. We're dealing with the motion filed by SPS. Mr. McMillan, can you confirm for me, it does, in reviewing this, they had requested confidential treatment of pages 9 and 10, which the version on Dropbox right now looks like it does address those concerns with redactions, and also Mr. Lai's work papers. To your knowledge, are both of those cover the redactions requested by SPS?
Your Honor, I believe that all of our exhibits that were marked confidential were redacted as they were requested to be redacted by SPS in the discovery responses. If there's anything in particular incorrect, we'd be happy to correct that. And my understanding is that we're mailing copies of those.
Hold on, you're breaking up. So before the court reporter interjects, go ahead and repeat your last statement. You have a weak communication. We're getting very garbled audio. There we go.
So, Your Honor, my understanding is that we have redacted all of the documents in accordance with SPS's confidentiality designations. If there's anything in particular that's incorrect, we'd be happy to correct that, as quickly as possible. But my understanding is we have them right.
Okay, Ms. Hardy, basically, why don't we'll revisit this before we begin tomorrow. Obviously, we're not expecting Mr. Lai to testify today. I'll grant the motion for protected information. Just ensure what has been loaded corresponds with the redactions requested. And if there's any changes of that, please let Mr. McMillan and myself know.
I will do
Okay.
that. Thank you.
All right. Next on my list, there were certain parties that all the parties have waived cross-examination time on. So we are going to admit their evidence onto the record as they do not need to appear. This includes Staff Exhibit 1, 3, and 5, which is the testimony of Jack Sidler, Tyler Crespin, and Alicia Liebert-Fisero. And from LES's witness, Michael Gorman, which I apologize, in my pre-hearing order, I had mistakenly stated Dan Gorman because I used to work with a Dan Gorman. That is LES Exhibit 1. So for purposes of those testimonies, Staff Exhibit 1, Staff Exhibit 3, Staff Exhibit 5, and LES Exhibit 1 are to be admitted onto the record. Any objection? Hearing none, those are admitted. And also during the pre-hearing, I had a request that we just to admit testimonies so we don't have to do the piecemeal recall. So for today, we only have SPS witnesses. And from what I see in Dropbox, pre-file testimony includes SPS exhibits 2, 3, 4, 5, 6, 7, 8, 9, and 10. Any objection, as the parties had no objections to any of the pre-file testimony, I would move that those be admitted onto the record. Any objection? Hearing none, SPS's exhibits 2 through 10 are admitted onto the record. And this is
Mr.
what I will
Examiner?
do. Yes, Ms. Hardy.
Apologies for the interruption. We had also provided Exhibit 10A, which is the confidential redacted version of Mr. Bornhoffen's direct testimony, his rebuttal testimony, actually, as well as SPS's application. And SPS's application is Exhibit 1. We did not upload the confidential version of the testimony into Dropbox. It was sent to parties who signed the protective order and also delivered to the commission.
Okay, let me deal with that one. Let me deal with that one when we get to Mr. Bornhoffen. In terms of your Exhibit 1, which is your application, I'm sure there's not going to be an objection. So let me move to admit SPS Exhibit 1 onto the record. Any objection? Hearing none, SPS Exhibit 1 is admitted onto the record.
Thank you.
And I think that concludes all the housekeeping that we had. Am I missing anything? Any other questions before we begin receiving evidence this morning?
Mr. Hearing Examiner, if I may, in the spirit of making things a little more efficient over the weekend, I know I reserved 10 minutes for Mr. Cooley and Mr. Bornhoffen on cross, and I believe I can dispense with those reservations now, waiving Mr. Cooley and Mr. Bornhoffen, but keeping the rest of my reservations, please.
Okay, so let me just scroll down. Okay, so we already admitted Mr. Cooley's. So Mr. Cooley, the parties have waived the cross-examination times to Mr. Cooley. Ms. Hardy, Mr. Cooley's presence this afternoon will no longer be required. And so now that will make me deal with Mr. Bornhoffen's. Okay, so SPS then, with no other parties requesting cross-examination time of Mr. Bornhoffen, Ms. Hardy, have you sent me the Exhibit 10A then? Where would I have that? Sorry.
I believe that we actually hand delivered it. I can have it emailed to you if that would be helpful.
Yeah, if you can email that to me directly, just so I can review it for purposes of the record, I would appreciate that. I can also, I can check with, you know what, actually allow me to check with my paralegal. And I'm not going to admit that onto the record right now, but I would deal with that when we get back from lunch, just to give myself some time to see if that had been hand delivered to my office. I'm sure it did. But I just want to review that before I admit it onto the record. That being said,
Understood.
all the parties have waived cross-examination time of Mr. Bornhofen. So for right now, his attendance this afternoon will no longer be necessary. Okay. Any other thing we need to do before we start our examination time? Hearing none. SPS, please call your first witness.
Thank you, Mr. Examiner. SPS calls Ms. Brooke Trammell.
Ms. Trammell, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Ms. Trammell, can you please state your full name?
My name is Brooke Trammell.
By whom are you employed and in what capacity?
I'm employed by Southwestern Public Service Company as Regional Vice President, Regulatory and Pricing.
Ms. Trammell, your direct and rebuttal testimony have been admitted into the record. Do you have any corrections to that testimony?
I do. I have one correction to my direct testimony and one correction to my rebuttal testimony.
And what is the correction to your direct testimony, please?
On page 25 of my direct testimony, table BAT2 lists the generation resources in SPS's current fleet. This table also has a column titled Currently Approved Service Lives or Service Life. Since the filing of this case number 23-00252 UT, SPS's current or at the time pending base rate case has been resolved. Therefore, some of the approved service lives in this table are now different, and I can update those dates based on, the currently approved retirement dates based on the Commission's decision in SPS's rate case 22-00286 UT. If you'd like, Ms. Hardy, I can step through those.
Yes, please. Thank you.
Unfortunately, this table does not have line numbers, so I'll go down the list by unit name. The first retirement date that was changed in our recent rate case was Plant X1. The listed retirement date in table BAT2 is 2019. That date is now changed by Commission approval to 2023. The next unit is Plant X2. Same change, 2019 is now 2023. And again, this is referring to the fourth column in the table titled Currently Approved Retirement Date. The third generation unit that was changed in the rate case is Cunningham Unit 1. 2019 is now 2023. The fourth unit that has changed is Nichols 1 from 2022 to 2028. The next unit is Nichols 2 from 2023 to 2027. And then on page 26, where table BAT2 continues, the next unit that was changed is Cunningham 2, 2025. I'm sorry, scratch that. That's a proposal in this case. I apologize. The next unit that is changed is Tolk 1, 2032 to 2028. And the final change to this table is Tolk 2, 2032 to 2028.
Thank you. And what is the correction to your rebuttal testimony?
On page 13 of my rebuttal testimony, in the first Q&A on that page, the first sentence in the answer that starts on line 3 and ends on line 4 has a footnote, footnote 19. That footnote refers to SPS's 2021 Integrated Resource Plan, case number 21-00169 UT. While the statement is true in terms of dispatchable generation being provided in SPS's 2021 IRP, the more appropriate reference for purposes of my rebuttal testimony in this case, and consistent with Mr. Elsie's rebuttal testimony also in this proceeding, that footnote should be referring to SPS's current Integrated Resource Plan proceeding, and that is case number 23-00073-UT.
Thank you. Do you have any other corrections?
I do
to your
not.
testimony. Mr. Examiner, I have no further questions for Ms. Trammell. She's available for cross-examination. Thank you.
Thank you, Ms. Hardy. And before we proceed, had a party just dial in on phone. Last digits are 1134. Can you please identify yourself?
Yes, Your Honor. This is Michael McMillan. My computer restarted again. I can proceed just on the phone until it's done ruining my day.
Okay, just checking to, whenever I see a phone number and not a name, I just like to make it clear someone else isn't listening in. Thank you, Mr. McMillan. All right, first request for cross-examination in the order that we have elected is OPL. OPL requested 2 hours and 20 minutes. So please proceed.
Yes, Your Honor. Good morning, Ms. Trammell. We've met before. My name is Michael McMillan, and I represent Occidental Permian Limited. How are you doing this morning?
I'm great. It was good to see you earlier, Mr. McMillan.
And hopefully it will be good to see me again here in just a couple of minutes. But in the meantime, we can at least get started in this manner. So I wanted to start out by talking about what the commission actually has to determine in this CCN case for SPS to move forward with these projects, and compare that to what SPS has asked the commission to determine. And normally I would be able to do this. Is there someone who is pulling up exhibits for the hearing?
If not, Mr.
If you
McMillan,
want-
I do have printed copies of all of OPL's exhibits here with me, if that would be desirable, given
Yeah,
your
that
audio
would
only.
be fine, given our tech limitations at the moment. So could you pull up OPL Exhibit 2, please? And that's a copy of NMSA Section 62-9-1.
Okay.
Okay, so NMSA 62-9-1 is the New Mexico statute that deals with certificates of convenience and necessity for utilities, correct?
Yes, it's titled New Construction Rate-Making Principles.
And so that's the statute that controls the commission's determinations in this case, right?
That's my understanding.
Okay, so far as you can tell, Ms. Trammell, is OPL Exhibit 2 a true and correct copy of that statute?
It appears to be.
Okay, Your Honor, I move OPL Exhibit 2 into evidence.
Ms. Hardy, any objections?
I don't object, Mr. Examiner, but I'm not sure it's necessary to admit a statute into the record.
Yeah, I'm going to take administrative notice of it. I don't think we really need it onto the record, but to the extent that this is a true and accurate copy of section 62-9-1, we are taking administrative notice of it. Proceed,
Okay,
Mr.
and
Malone.
Your Honor, just so I know going forward, would you like me to have you take administrative notice of commission orders as well?
To the extent you don't have to move them onto the record, I'll probably just similarly do what I just did. I recognize that for the most part, we do this because it's Zoom hearings, so everyone can be looking at the same thing. So to the extent that they are a public document or a record of a statute, I'll take administrative notice of it for the record.
Excellent. Okay, well, I can move forward on that basis. So, Ms. Trammell, if you could first look at Section A of that statute. In Section A, it states, no public utility shall begin the construction or operation of any public utility plant or system, or of any extension of any plant or system, without first obtaining from the Commission a certificate that public convenience and necessity require or will require such construction or operation. Did I read that right?
You did.
Okay, so in other words, the primary issue in this case is whether the public convenience and necessity requires or will require the construction and operation of the generation facilities at issue here, right?
Mr. Examiner, I object to this question.
Basis, Ms. Hardy?
I think it calls for a legal conclusion.
Your Honor, Ms. Trammell is the head is one of the people in charge of regulatory for SPS, and she sponsors a large portion of this application. I think she's qualified to give an opinion on what the purpose of a CCN application is.
Correct. She's allowed to state her opinion to the extent that a legal conclusion would be provided by counsel. Obviously, this hearing examiner is well aware of that. So in her opinion, she can state what her opinion is.
Thank you, Your Honor.
Ms. Trammell, do you need me to repeat the question?
No, sir. I agree with you that that first sentence in Section A of this statute is a primary purpose of this or any CCN proceeding. I would also state that the first sentence of Section B is clearly identified in the statute as an item of primary importance in a CCN as well, if a utility requests determination of rate-making principles and treatment in a CCN proceeding.
Okay, and we'll get to Section B in just a second. I do intend to talk about that, but for right now, Section A definitely requires the Commission to determine if the public convenience and necessity requires or will require the construction and operation of the generation facilities at issue. Is that right?
Yes.
So in other words, the Commission has to determine whether these facilities are needed.
Correct.
And as part of that, the Commission has to determine whether the projected costs to build those facilities are at least facially reasonable, right?
I'm sorry, what's reasonable?
Facially reasonable.
Thank you.
I don't believe that requirement is actually outlined in this statute, but the Commission does have rules that outline requirements for certificated cost estimates and CCN proceedings from utilities.
And that is something that the Commission generally does consider and determine in the course of CCN proceedings, correct?
To clarify, you mean review cost estimates?
Yes.
Yes.
Okay, so let's look now at NMSA section 62-9-1B. Now, this section of the statute gives SPS the option to ask the Commission to address rate-making treatment for facilities in a CCN proceeding, right?
Correct. It says may.
Okay, so let's read through that section just to make sure we're all on the same page. The portion, starting around the portion that you just noted, it says, if a certificate of public convenience and necessity is required pursuant to this section for the construction or extension of a generating plant or transmission lines and associated facilities, a public utility may include in the application for the certificate a request that the commission determine the rate-making principles and treatment that will be applicable to facilities that are the subject of the application for the certificate. Did I read that sentence correctly?
You did.
And then it continues, if such a request is made, the commission shall, in the order granting the certificate, set forth the rate-making principles and treatment that will be applicable to the public utility stake in the certified facilities in all rate-making proceedings on and after such time as the facilities are placed in service. Did I read that right?
You did.
So you state in your testimony, and you'd agree with me, that this portion of the statute gives the commission broad discretion to determine rate-making issues in the context of a CCN case, correct?
That's correct.
But that section of the statute does not require the commission to address every aspect of rate-making and for the facilities that are the subject of a CCN, correct?
The second sentence does. Not the first one you read, but the second sentence says the commission shall.
Well, it says that the commission shall set forth the rate-making principles and treatment that will be applicable, but it doesn't necessarily require the commission to address every aspect of rate-making, correct?
I think it's up to the commission to determine which rate-making principles and treatment would be applicable. And that's the discretion they have, the commission has, in writing its final order in a CCN.
Okay, so because it's up to the commission to determine what rate-making treatment to include in a CCN order, the commission doesn't necessarily have to address every aspect of rate-making that a utility raises in its CCN application, correct? It has discretion to not address those if it wants to.
Mr. McMillan, while I'm generally okay opining, given my role at SPS, I'm not comfortable saying what the commission should or shouldn't do or has to do.
Okay, so is it SPS's position that the commission has to address and take a position on every aspect of rate making that SPS requested in its CCN application?
We would certainly prefer if the commission did. We think the rate-making requests that have been outlined in this proceeding and are discussed in more detail in my testimony, as well as the testimony of other SPS witnesses, provide certainty to the commission and to the parties and to our customers on how cost recovery of these projects will be handled going forward. We also think it's important for the parties in this case to review and get a determination from the commission on many of these factors, because they will outline, the commission's determinations on these rate-making requests will outline how quickly some of the customer benefits of these proposed projects would be returned to customers and through which mechanism. It also outlines the cost allocation parameters, which we expect are of most importance or material importance to the interveners in this proceeding. So it's our position that determining these rate-making matters in this proceeding is in the public interest, and we encourage the commission to do so.
Okay, but directing you back to my question, is it SPS's position that the commission is required to address all of them?
We think that determination is something that the commission can make on what's required.
Okay, so you would agree with me that in this statute, the legislature did not explicitly require the commission to address retail class cost allocation in a CCN order. Is that right?
It does not, the statute does not specifically outline retail cost allocation, no.
And are you aware of any previous instance where SPS has asked the commission to address retail class cost allocation in a CCN proceeding?
I don't recall if we requested the class allocation or not in the Hale and Sagamore wind CCNs. We've certainly usually always addressed jurisdictional cost allocation in CCN proceedings at SPS.
Okay, and so the statute also does not explicitly require the commission to address the treatment of tax credits in a CCN order. Is that right?
No, it does not. I
And
presume
is-
the statute probably predated some of the federal renewable tax credits that are available today.
That makes sense, but regardless, it doesn't explicitly address them, right?
It does not.
And are you aware of whether SPS has ever previously asked the commission to address the treatment of tax credits in a CCN proceeding?
We have. We did request treatment of the flow through of federal production tax credits to customers through SPS's FPP-CAC, or Fuel and Purchase Power Cost Adjustment Clause, in those wind CCNs that I referred to for Hale and Sagamore, case number 17-00044-UT.
Okay, so I want to talk about what the practical effect of a determination on retail class cost allocation, or a determination on the flow through of tax credits, how those would actually end up in customers' rates. So there's a couple of proposals here, right? So on one hand, the commission could go the direction that SPS wants and have the self-build solar projects at least flow through SPS's renewable portfolio standard, or RPS rider, correct?
That is not our proposal in the case. Our proposal is to flow the tax credits back to customers in the month they are generated with regard to the production tax credit for the solar facilities in the month following the start of recovery, or when recovery commences on the revenue requirement of the self-build projects. But the flow through mechanism proposed by SPS is SPS's fuel clause, not the RPS rider.
Gotcha. Thank you, Ms. Trammell, for that clarification. I stated that poorly. So as you mentioned, though, the cost of the facilities, there are two ways that could potentially get into customers' rates. The first being that the self-build solar facilities would go into rates initially through SPS's RPS rider, correct?
There's actually three ways contemplated under the Commission's RPS rule, Rule 572.
Could you explain what those are?
Yes, I can pull the rule up and we can look at it together, but by memory, Section 15 of the RPS rule, again, Rule 572, contemplates that the revenue requirement or costs of PPAs, self-builds, and or build transfers can be recovered through the RPS rider, can be recovered via a deferral with a WACC return, or they can be recovered through fuel. SPS proposed the RPS rider, but those three methodologies are contemplated in Rule 572.
Gotcha. Okay. Well, let's look right now just at SPS's proposal. So SPS has proposed to put the cost of the self-build solar facilities through the RPS rider. Is that right?
That's correct.
Okay. And another option that the commission has is it could wait until the facilities go into service and then SPS files a base rate case, correct?
I disagree with the definitive nature of wait until the facilities go into service, but yes, rate case recovery would be another option for utility generation investments. Again, that's not outlined in 572, but that is, of course, another option.
Okay, so the rate making treatment that SPS is asking for in this CCN proceeding on a retail class cost allocation. Now, the only way that would matter as far as customers' rates go is if the facilities eventually go into rates, correct?
That one I'm going to ask you to restate the question. struggling to follow you through all that.
Sure. So the determination, and let's stick with the retail class cost allocation right now. So that determination would only become effective and would only impact customers' rates once the facilities are placed into rates, correct?
Do you mean into base rates or into rates
Well,
more generally?
Into rates more generally.
In terms of the cost allocation, which is what I think your question was asking for, it would matter for any recovery mechanism.
Well, yes, but the amounts would not actually make their way into customers' rates until a future commission order, be that in an RPS proceeding or a base rate proceeding, correct?
That's correct.
Okay, so if the commission, let's say, rejected SPS's request to recover the self-build solar facilities through the RPS rider, then the commission could, in theory, address retail class cost allocation in a base rate proceeding, and then the cost allocation would go into effect at the end of that base rate proceeding, correct?
In that hypothetical example where we are requesting recovery in a rate case, that would be correct.
And same thing with the tax credits, correct? I mean, if the commission rejects the request to put the self-build solar facilities into rates through the RPS rider, the commission could make those determinations in a later rate case along with the rest of the determinations about these facilities, and then flow those into rates at the end of the base rate case, correct?
The commission could. I think that would significantly reduce the benefit of available federal tax credits on these projects to customers. In other words, customers would not receive as many tax credits under that scenario as they would under SPS's proposal. The credits would begin to be generated or would be received in the context of an investment tax credit, like for the batteries, but those credits, the value of those credits would not be flowed back to customers until the effective date of rates of the case you mentioned. Again, that would be a reduction in the customer value of these projects.
Okay, I want to dig into that just a little bit more and talk more about SPS's request to recover the self-build solar facilities through the RPS rider. So broadly speaking, SPS is asking the commission to allow it to put the cost of the self-build solar facilities into rates through the RPS rider between the in-service date of the facilities and SPS's next base rate case, correct?
SPS's original request in the case was to keep the revenue requirement for the SPS solar facilities in the RPS rider for the life of the projects. That's consistent with the commission's determination in our 2012 rate case that established the RPS rider, that the commission desired to see all projects and costs needed for RPS compliance recovered through one mechanism. And so that was our original request, was to keep the recovery in the RPS rider. In our rebuttal case, we discussed that we would be open to transferring the costs into base rates with each rate case that was subsequently filed, if that, or the next rate case that was filed after COD, if that was what the commission desired. Again, recognizing that it's the commission's original intended stated purpose was to keep all RPS costs in one recovery mechanism, which today is the RPS rider.
Okay, so in other words, SPS is fine with either of those results, either putting the self-build solar projects into the RPS rider and leaving them there, or putting them there just until the next base rate case.
Correct.
Okay, so to be clear, if the commission pre-authorized recovery of the self-build solar projects through the RPS rider, that would be really beneficial for SPS, right?
It would be consistent with the commission's stated opinion on the establishment of the RPS rider in our prior rate case. It would also be very beneficial for the company, and it would be beneficial for customers. The RPS rider is subject to true-up. Our base rates are not subject to true-up, as I think most in this proceeding understand, the RPS rider is trued up annually, both from a cost perspective as well as a sales perspective. So it is a very accurate recovery mechanism for customers.
Okay, so based on that true up in the RPS rider, that means that if the commission authorized RPS rider recovery, that would guarantee that SPS would fully recover the cost of those assets plus a return for as long as they're in the RPS rider, right?
Assuming the commission determined that all of SPS's invested capital and cost expended to operate and maintain the facilities were found prudent.
Okay, so flowing the cost of the self-build solar projects through the RPS rider would also mean that those facilities would get into SPS's rates significantly earlier, right?
I don't know that it would be significantly earlier. The commission's application of a future test year rate case could match recovery of the revenue requirement on the self-build solar projects roughly commensurate with the time of COD if the case was processed in a manner to produce that kind of timing.
Okay, speaking of timing, has SPS committed to the timing of its next base rate case?
No, it has not.
And what is the anticipated in-service date of the self-build solar projects?
Plant X1 and 2 solar, generally referred to as Plant X solar in this proceeding, has an in-service date in April of 2026. Cunningham 1 solar also has a April 2026 in-service date. And the Cunningham 2 solar project is planned for an in-servicing in April of 2027.
Okay, so that means that if SPS for those first two projects filed a base rate case at any time after, what is that, April of 2025, it could potentially request recovery of those through a future test year, correct?
Potentially, yes.
And the same for the third project, it would be just April of the following year, correct?
Correct. If those two requests were both future test year cases.
Okay, and the way that would look if SPS put these facilities in through the RPS rider is the projects would go into service and then SPS would file an RPS case and request that they be included, or could SPS do that before the in-service date of the projects?
SPS could file as you outlined, but could also file before. So in the example of the 2026 solar projects, SPS could file and request recovery of those solar projects revenue requirement in its 2025 RPS filing. So the 2025 RPS filing would present the rider for calendar year 2026, and that rider could be inclusive of the revenue requirement for the solar facilities in that are going into service in that year.
Gotcha. So would you agree with me that filing an RPS case is significantly easier thing for SPS to do than filing and litigating a base rate case?
Traditionally, it has been.
Okay, and let's just assume for purposes of these questions that putting the self-build solar facilities into the RPS rider would result in an earlier recovery for SPS. I understand I'm creating a hypothetical, but could you follow along with me on that?
Can I make one clarification?
Sure.
I agree the RPS rider would start earlier. The annual revenue requirement in the rider would still be commensurate to the level of the first year revenue requirement in a base rate case.
Okay, yeah. So in other words, it would be the same amount, but earlier, right?
Correct.
Okay, so in that world where you get the same amount of recovery, but you get it earlier, that means that SPS would be earning a return on the self-build solar facilities earlier, right?
Well, we would start recovering earlier. Again, it's the same recovery amount. The rider would just start January 1st, in my example, 2026. A rate case filed on the timeline you identified potentially would begin the effective data rates later in that calendar year.
Okay, so having that recovery start earlier, that decreases risk for SPS, correct?
Again, the same amount of recoveries occurring, the riders just appearing on customers' bills earlier in a established commission mechanism. I think the overall risk determination would be whether or not commensurate or relatively commensurate cost recovery is occurring based on commission decisions.
Okay, so back to my question here, though. The question is whether it's better for SPS and decreases risk for SPS to start recovering on the self-build solar facilities earlier rather than later, and it is, right?
It is.
Okay, and that, in other words, it would decrease regulatory lag, right?
For these projects, yes.
Okay, so we've talked about why RPS rider recovery might be good for SPS. Now let's look at it from customers' perspective. So if the self-build solar facilities, went into the RPS rider and SPS started recovering or started charging rates that included those facilities earlier, that means that customers' rates would go up sooner, correct?
By a lesser amount.
Because as you noted, the recovery would be for the same total amount and just spread over a different period of time?
Correct. In the RPS rider.
Okay, but if they went into the RPS rider, that means that customers' rates would go up earlier, right?
Yes, and those rates would also start presumably close to the time that the PTC and ITC credits under SPS's proposal would also be transferred to customers through fuel. So we're matching cost recovery with the timing of the flow-through benefits. The alternative would be all of those mechanisms occurring in base rates, both the cost recovery and the PTC flowback. And again, that would prevent the earlier acquisition or earlier receipt of those PTC benefits by customers.
Okay, and that's exactly what I wanted to get into next. So regardless of if we use the RPS rider or base rates, the flowback of the PTCs starts when the cost recovery starts, right?
Correct.
Okay, and you mentioned before and just now that if we went through the RPS rider, that means that customers would start getting the benefit of the PTCs earlier, correct?
Correct, assuming the commission authorizes the flow through of the credits through the fuel factor. I should have stated that earlier, Mr. McMillan. That is a request the commission needs to authorize.
Gotcha. And so let's just assume hypothetically for these questions that they do that. And thank you for that clarification. So to be clear, Ms. Trammell, the benefit of the tax credits associated with the self-build solar facilities is not going to be enough to fully offset the rate increase that customers will experience when those facilities go into rates, right?
In year one, it could be a very significant offset to the revenue requirement. I believe Mr. Fetters has an annual presentation of the costs and PTC levels for the SPS self-build solar projects in his testimony. Given the 10-year horizon for the available federal production tax credits, the revenue requirement in those first 10 years could be significantly, if not entirely, offset by the available tax credits.
Okay, and we can look at that with Mr. Fetters, but on net, assuming the tax credits do not fully offset the revenue requirement of these facilities, putting them in through the RPS rider would mean that SPS's customers would start paying higher rates, right?
You cut out at the end of that question. Could I ask you to restate it again?
Sure. So we'll talk about the exact numbers with Mr. Fetters on the offset, but in a world where the tax credits do not fully or more than fully offset the revenue requirement associated with the self-build solar facilities, putting those facilities into rates through the RPS rider would mean that customers start paying higher rates sooner, right?
All else equal in the RPS rider, I can agree with your hypothetical, but I think the rate impact, again, of the self-build solar facilities, particularly in the first year, would be pretty minimal given the PTC value.
Okay, so I want to talk about how using the RPS rider for the purpose that SPS has proposed would impact the way that rider looks. You would agree that putting the self-build solar facilities into the RPS rider would significantly increase the size of that rider compared to today, right?
Potentially, yes.
Okay, so I'd like to look at OPL Exhibit 6, which is a copy of SPS witness Jeffrey Comer's direct testimony from your most recent RPS proceeding. Can you tell me when you've got that up? And I'm specifically going to be looking at page 12.
I don't have the service or the filing cover letter for this testimony, but there is a certificate of service in the back, and this does appear to be Mr. Comer's testimony from case 23-00230. And you said page 12, Mr. McMillan?
Yes.
Thank you.
And Your Honor, I was going to get to the authentication with Ms. Trammell, but since she very nicely did that for me, could we have you take judicial notice of this direct testimony from SPS's most recent RPS proceeding?
Ms. Hardy, any objection?
No objection.
All right.
Okay, Ms. Trammell, on page 12 of the Bates numbering of that document, do you see where Mr. Comer discusses the 2024 revenue requirement for SPS's RPS rider?
The revenue requirement is discussed on Bates page 16, not 12.
I may just have the wrong page number written down, but it in the document you're looking at is the revenue requirement approximately $6.4 million.
Yes, and just to clarify for the hearing examiner and court reporter, it's page 12 of the testimony, Bates page 16.
I understand now. Okay, so the revenue requirement for the most recent iteration of the RPS rider is $6.4 million, right?
Approximately, yes.
And there was an overcollection in a prior period, so it's actually fair to look at the projected costs that go into the RPS rider in 2024. And I forget if it's at the bottom of that page or on the next page potentially, but the projected RPS costs for 2024 are $13.4 million.
That's correct. It's actually in the next sentence. The projected costs for 2024 is the 13.4 million netted, as you stated, by 6.9 million in over recovery.
Okay, so do you know roughly what amount would be added to the RPS rider if the commission were to approve the inclusion of the self-build solar facilities in that rider?
I do not recall the revenue requirement for the self-build solar projects in year one, but I believe Mr. Fetters has that information.
Okay, and we can talk with Mr. Fetters about that. But so just at a very high level, though, if we wanted to figure that out, we would take the total cost of the self-build solar facilities and multiply it by SPS's rate of return from its most recent base rate case, correct?
That's correct.
Okay, and it's safe to say, just based on the current size of the RPS rider and the size, and I know you don't know it off the top of your head, but the size of the SPS self-build solar facilities, that including those facilities in the RPS rider would increase the size of that rider by multiple times, right?
In your example, I would expect the RPS rider, all else equal, would be greater than that 6.4 in 2024. Yes.
So I'd like to talk a bit about the purpose of the RPS rider. So the purpose of that rider is to reflect the cost of compliance with New Mexico's RPS mandates, right?
Yes.
Okay, and to be clear, SPS is not proposing the self-build solar facilities to satisfy the legislature's RPS mandates, correct?
Well, as you stated, this is not an RPS case. So SPS is not presenting its RPS plan and report for these applicable calendar years, say starting in 26 and 27 in this proceeding. SPS will,
Okay.
as my testimony outlines and staff's testimony reflects, expect to need and to retire RECs from the SPS self-build solar projects for RPS compliance in the future.
Well, sure, because they're renewable projects, you will count them toward your RPS goals eventually. But as of right now, SPS does not need these facilities to satisfy the minimum goals of the RPS, right?
Well, we don't need them in the current years because they won't be in service. And we do bank RECs for future years compliance, but we do anticipate once these projects are in service that we will need to record RECs received from these facilities for RPS compliance, whether that's retiring them in a current year or banking them for compliance in a future year, I don't think matters.
Okay, so currently SPS is above the requirement, the RPS requirement for 2025, correct?
Again, on our system, yes, we are. We continue to bank RECs though and only retire the amount of RECs required for RPS compliance in each particular plan year.
Okay, and the next time that SPS's RPS requirement increases compared to the 2025 minimum is in 2030, correct?
Yes.
Okay, and you addressed this in your rebuttal testimony. The purpose of SPS proposing these projects right now is as capacity resources to meet SPS's capacity and energy needs, right?
Can you state that again? Sorry, I was thinking about the RPS and I believe there's actually a requirement in 2025 as well.
Well, I think we talked about that, Ms. Trammell. SPS is currently ahead of the 2025 target already, right?
We are technically on the system, but again, we have not retired RECs ahead of today's requirement. So then I think your question was, when does it increase again? And we talked about 2030. I think technically we will increase in 25. We will retire RECs to satisfy the increased requirements in 25 through 2029. And then to your point, the required amount increases again in 2030.
Gotcha. So would you agree with me that the purpose of SPS's RPS rider is to recover the incremental costs of RPS compliance?
That's how the rider has been utilized in the past. That's how SPS has requested. That's the cost that SPS has requested in the past to be through the rider.
Okay, so just to solidify that, I'd like to look at OPL Exhibit 8, which is a copy of SPS's response to the New Mexico Attorney General's Discovery Request 1-01. Can you let me know when you have that up?
I have it.
Okay, now you sponsored this response, correct?
I did. I co-sponsored it with Mr. Fetters.
Okay, and does that look like a true and correct copy of that discovery response?
It does.
Your Honor, I move OPL Exhibit 8 into evidence.
Request is for OPO Exhibit 8 to be admitted. Any objection?
No objection.
It is admitted.
Okay, so Ms. Trammell, in the first sentence of that response, you state, SPS's RPS rider collects incremental costs for complying with the New Mexico Renewable Energy Act. Did I read that right?
Yes, and that's in response to the question of how are the costs currently allocated?
Understood. And so after saying that the rider currently recovers incremental costs, you give some examples of what those incremental costs are, right?
Yes.
Okay, so you state that incremental RPS costs include wind and solar renewable energy credit costs, uneconomic energy costs under the SunEdison PPAs, distributed generation incentives and administration costs, and Western Renewable Energy Generation Information System registration costs, right?
That's correct. Those are, again, current costs recovered, current incremental RPS costs recovered through the rider.
Okay, so do you agree that the Commission's intent in establishing the RPS rider in that case you mentioned earlier, case number 12-00350-UT, was to capture those incremental costs of RPS compliance?
Objection.
No, I do not. Oh, sorry, Ms. Hardy.
Basis of the objection, Ms. Hardy.
Mr. McMillan is asking Ms. Trammell to testify regarding the commission's intent.
To the extent that she doesn't know the intent, I would take it under consideration. She can in her state in her opinion.
Thank you, Your Honor. I
Okay,
certainly don't know what the commission's intention was, but I am familiar with the language in that decision, and I do not recall that incremental was the intended purpose of the recovery. I believe the commission's decision, and we could look at it, Mr. McMillan, because I believe there's a copy of that in your exhibit list as well, but the intention was to recover all costs of compliance.
Okay, so let's go ahead and do that. So it's OPL Exhibit 4 is a copy of the Commission's final order in case number 12-00350-UT. And you can let me know when you have it up, and we're going to be looking at page 22, paragraph 47.
I have it.
Okay, and Your Honor, could I request that you take judicial notice of OPL Exhibit 4?
Ms. Hardy, any objection to this exhibit?
No objection.
It is admitted. Mr.
Okay,
McMillan,
so
could you clarify which page number you were referring to?
I believe it's page 22 of the order. It's paragraph 47.
Thank you.
And Mr. Examiner, I believe Mr. McMillan had requested administrative notice of the order.
Thank you. Administrative notice was taken of the order from case for OPO's exhibit number 4.
Okay, so Ms. Trammell, are you at paragraph 47 of that order?
I am.
Okay, so in that paragraph, the Commission states, the establishment of the RPS rider and the inclusion of the uneconomic SunEdison costs in the RPS rider will provide an appropriate mechanism to capture all of SPS's incremental RPS costs through one recovery mechanism and will benefit customers. Did I read that right?
You did. I think in this order, paragraphs 44 and 45 are also informative of the Commission's intention with regard to recovery of renewable energy costs through the RPS rider.
Okay,
This
so
paragraph
real quick.
47 is referring, as you can see in the language, specifically to some of the issues around those SunEd costs.
Okay, but looking further down in paragraph 47, I believe it's the next sentence, the Commission continues, renewable energy is the only source of power that a public utility obtains pursuant to a statutory mandate. And subject to the RCT, renewable energy has to comprise a certain percentage of a public utility's total retail sales to New Mexico customers, regardless of need or cost. it is not only not unreasonable, but it is desirable to communicate to customers the cost of this mandate. Did I read that right?
You didn't finish the rest of that sentence, but what you read was correct.
Okay, so in that section that we just went through, the commission is saying that one of the purposes of the RPS rider is to capture the incremental costs of meeting these minimum mandates and to provide customers with some communication regarding the costs that they're incurring to satisfy those mandates, right?
Yes, that's one intention.
Okay, so I'd like to go a little deeper into what the incremental costs of RPS compliance are. If you could pull up OPL Exhibit 3, which is a copy of the Commission's RPS Rule 17.9.572.
Okay.
Okay, Your Honor, could you take judicial notice of the Commission's RPS Rule 17.9.572?
Give me 1 second. Okay, seeing as how OPO Exhibit 3 is reference to Title 7, Chapter 9, Part 572, I'm taking administrative notice of it.
Okay, so Ms. Trammell, could you look at 17.9.572.7 R5, the definition of the renewable portfolio standard, and let me know when you're there.
Did you say 7R?
7R5.
I don't see a 7R.
There is no 7R.
I may have mistranscribed that. It's the definitions section under R5.
I see the definition section. Which word would you like me to look for?
It's renewable portfolio standard is what we're looking for.
F.
That would be F.
Close to an R. I see it.
0.7. Hang on just a second. R. Anyway, okay, so the definition of renewable portfolio standard is the minimum percentage of retail sales of electricity by a public utility to electric consumers in New Mexico that is required by the Renewable Energy Act to be from renewable energy. Did I read that right?
Hold on.
You did not.
Mr. McMillan, that is not the definition on your exhibit.
One moment. Let me find where I'm.
Your Honor, I do apologize. There's a slight delay in my audio. I believe I started to speak about the same time you did. I will refrain from interrupting you. I apologize for that.
No problem. I'm trying to follow along as well here, so no issue.
I believe there may be a version issue in the moment. Let me see.
Okay, well, we're going off the version you supplied, Mr. McMillan.
Yeah, no, as we should, Your Honor. My apologies. Okay, so just talking more generally, we can move on from the exhibit. Speaking more generally about the incremental costs of RPS compliance. Incremental in that context means the cost the utility incurs solely to comply with that minimum RPS mandate that would not have otherwise been incurred by the utility in the absence of that mandate, right?
Mr. McMillan, can you refer me to the definition of incremental in Rule 572?
No, so we've moved on from that rule because of apparently I either submitted or was looking at the wrong version earlier. But in, say, the prior order that we were just discussing, and in that context, and in the context of the current RPS rider that SPS uses, incremental costs of RPS compliance is costs that SPS incurs solely to meet that minimum RPS standard that it would not have otherwise incurred, correct?
I don't recall a definition in the order that we were discussing earlier, the final order partially adopting the recommended decision from case 12-350.
So that paragraph 47 that we talked about earlier, it did say that the RPS rider will provide an appropriate mechanism to capture all of SPS's incremental RPS costs. It did say that, right?
Again, it's referring to the uneconomic SunEdison costs in that sentence and the appropriateness that the commission found, which was different than the finding of the hearing examiner in that case, that the uneconomic SunEdison costs would be it would be appropriate to recover those through the rider. The sentence does refer to incremental costs, but I believe it's referring primarily in that sentence to the commission's discussion of changing the hearing examiner's recommendation with regard to the recovery of uneconomic SunEd costs.
Well, and the uneconomic SunEd costs are in SPS's RPS rider, right?
They are now, yes.
Okay, so the uneconomic portion of the SunEdison costs, you would agree with me that those are an example of the incremental costs of RPS compliance, right?
Yes.
And that's because they were costs that SPS would not have incurred because they're uneconomic in the absence of the minimum RPS mandate, right?
At the time, that's correct.
Okay, but it did acquire those to meet the minimum RPS mandate, and then it reflected those the uneconomic portion of those costs, the incremental costs in its RPS rider.
That's right.
Okay, so you agreed with me before that SPS is not constructing the self-build solar facilities to satisfy the minimum requirements of the RPS in the short term, right?
Correct.
Well, I was going to object.
Basis of the objection, Ms. Hardy?
I think Ms. Trammell answered this question previously. Asked and answered.
And Your Honor, I'm just reorienting the witness so we can move on to a slightly different topic. I can just get right into it if
yeah, let's just get into it. And I'll just note that you probably have about 8 minutes before we take a break as well.
Okay.
So just giving you a heads up to find a good breaking point too.
Okay, I'll let you know if I get to a good spot, Your Honor. Okay, so Ms. Trammell, could you pull up OPL Exhibit 9, which is SPS's response to NMAG Discovery Request 2-6?
I have it.
Okay, so does this appear to be a true and correct copy of a discovery response that you sponsored?
Yes.
Okay, Your Honor, I move OPL Exhibit 9 into evidence.
Request is for OPL. I'm sorry. Are we doing 8 or 9, Mr. McMillan?
9, Your Honor.
Sorry, I pulled up the wrong one. Request is for OPL Exhibit 9 to be admitted onto the record. Any objection?
No objection.
It is admitted.
Okay, so Ms. Trammell, in this response, you state that the concept of economic screening as it relates to the RPS rider and uneconomic cost recovery relates to generation that is solely procured to meet the requirements under the RPS standard, right?
Yes, that's what it says.
Okay, and then down at the end of the response, you state that these resources, meaning the resources that are the subject of this CCN proceeding, were not chosen solely through an RPS plan, right?
1 second. I'll admit this is a long sentence, so I'm going to start from the top.
Okay.
Yes, that's correct. These resources, the sentence reads, these resources were not chosen solely through an RPS plan
Okay, and you also state in that sentence that no part of the costs are considered uneconomic, right?
Because, as we state at the beginning of the sentence, the costs associated with the SPS solar projects are consistent with SPS's action plan from its 2021 IRP, revised in its November 17th filing, case reference. Therefore, the costs are not considered uneconomic.
Okay, and so given what we were just discussing about the definition of incremental, or rather the meaning rather than definition of incremental costs in terms of RPS compliance, you'd agree with me that the costs of the self-build solar facilities are not incremental costs of RPS compliance, right?
Well, they would be in the future if we're retiring RECs from these facilities for RPS compliance.
But they're not currently, right?
They're not in service.
Well, fair enough, but they would not be as of the in-service date of the projects, right?
I disagree.
That is what you're saying, that by the time these go into service, they will be needed to meet SPS's minimum RPS requirement that is in effect at the time they go into service?
My testimony is they could be. We'll be projecting our RPS compliance needs closer to that plan year, but we fully anticipate and expect that RECs from these facilities will be needed for RPS compliance in the future. Exactly how many RECs will we need to retire, say for the 2026 ISD projects in 2026, I can't tell you today.
Okay, so is it fair to say that SPS will not be needing all of the RECs from these projects to meet compliance as of their in-service date?
That's impossible to know today.
Okay, so at this point, you can't tell us one way or the other.
I can't tell you the exact or precise number of RECs that will need to retire from these facilities, but again, we fully expect that RECs from these facilities, both the 2026 in-service solar as well as Cunningham 2 project in 2027, will be needed for RPS compliance in the future.
Gotcha, but you can't tell us when in the future, right?
Not today.
Okay, so Ms. Trammell, it's because of the energy transition toward renewables and low carbon generally, it's fair to say that over time, renewable energy facilities are going to become a larger and larger portion of SPS's portfolio, right?
I would say clean energy resources will become a larger and larger component. We have significant dispatchable needs on our system, and renewable energy only will not satisfy the needs of our high load factor system.
Okay, is it SPS's position that the full cost of any new renewable energy generation can be flowed through the RPS rider, even if that generation is not needed to satisfy the legislature's RPS minimum?
No, I think the Rule 572 contemplates that costs associated or needed for RPS compliance, again, can go through one of three recovery mechanisms: the RPS rider, a deferral with a WACC return, or fuel. I would not expect costs that are not directly related to RPS compliance to be recovered through the RPS rider or one of those other two mechanisms.
Okay, thank you. Your Honor, I think now would be a decent time to take a break, and I could pick up from here pretty easily after the break.
Okay. We've gone for an hour and a half. I've got 10:29, so let's take a 10-minute break and we'll resume at 10:40.
Thank you.
Allison, you good on your end? Do you need any information?
No, I don't need any information. I'm just wondering if maybe Mr. McMillan could utilize the break to perhaps get back on. His audio is less than ideal. I don't know if that's possible.
Yeah, I'm working on that right now, and hopefully it will be better on my computer.
Thank you, sir.
Okay, I have 10:40, so let's get everyone back. Okay, Madam Court Reporter, are you ready? Okay, let's go back on the record. Mr. McMillan, you may proceed. Sorry, McKillen. McMillan.
Yeah, so Your Honor, over the break, I figured out what the issue was with OPL Exhibit 3. Apparently OPL Exhibit 3 was the 2013 version of the rule that was inadvertent. So to the extent that Your Honor took judicial notice of that, I would appreciate you taking judicial notice of the current version of the rule as of February 28th, 2023.
Okay, let me just. All right. To the extent that the prior exhibit did not contain the updated rule, I will take note of that. And
okay,
that's the new version.
Okay, and Your Honor, if I may briefly circle back to that version, the newer version of the rule, if you don't mind, I can move on if you'd like, but would like to clarify for the record.
Yeah, I think we have made our point on that, so let's move along, would be my preference.
Okay, I can address it in briefing here.
That's fine.
Okay, so Ms. Trammell, let's go ahead and move on. And SPS has not yet explained how it would modify its RPS rider to accommodate the recovery of the self-built solar facilities, right?
I disagree. We've outlined the revenue requirement calculations, and we've outlined the jurisdictional and class allocation methodologies that we would bring into the RPS filing in the applicable rider year.
Okay, but you don't yet have a proposed tariff, for example, for the updated RPS rider.
No, again, the RPS rider is recovered, the cost through the RPS rider recovered on an annual basis, and the rider and the tariff is revised each year with SPS's July plan and report filing.
Okay, so let's pull up OPL Exhibit 10, which is SPS's response to OPL's Discovery Request 3-5.
Okay.
And that's a discovery response that you sponsor, correct?
Yes.
And does that appear to be a true and correct copy of that response?
Yes.
Your Honor, I offer OPL Exhibit 10.
OPL Exhibit 10. The request is for OPL Exhibit 10 to be admitted on the record. Any objection?
No objection.
It is admitted.
Okay, so Ms. Trammell, as you discuss in response to OPL 3-5, SPS does not currently have a proposal for the modifications that it would make to the RPS rider, right?
We do. I think part of it's outlined in this discovery response.
Okay, but you have it at a high level, but as we stated, you haven't proposed the exact structure of the rider and how that would work, right?
I haven't quantified, say, for example, the exact 12 coincident peaks that we would use to allocate the costs from the prior year, because that year is in the future and I don't have those peaks today. But I've outlined the framework by which this rider would be implemented.
Okay, but the specifics of that would have to be worked out in a future RPS proceeding, right?
I think the specific data would need to be collected by SPS, but the parameters would not need to be worked out in a future RPS filing.
Okay, well, let's talk about one of the kind of high-level parameters that SPS has proposed for the future RPS rider. So it would include a significant change to how the costs in the RPS rider are allocated to SPS's retail customer classes, right?
It's pretty traditional that production capacity costs are allocated to SPS's customers on a production demand basis. There are currently today no production demand costs in the rider, so that would be a difference, but the allocation methodology would follow the nature of the costs being recovered through the rider.
Okay, so to be thorough here, let's look at OPL Exhibit 11, which is SPS's response to OPL Discovery Request 1-1.
Okay,
Okay, and you sponsored that response?
I did.
And does OPL Exhibit 11 appear to be a true and correct copy of your response?
Yes, it does.
Okay, Your Honor, I offer OPL Exhibit 11.
Request is for OPL Exhibit 11 to be entered onto the record. Any objection?
No objection.
It is admitted.
Okay, so Ms. Trammell, as you just noted, and as you explained in response to OPL 1-1, one of the broad changes that you would make to the RPS rider is changing the class cost allocation such that the rider would be recovered using an AED 4CP production capacity allocation factor, right?
That's not quite correct. We are not proposing to change the way the costs are recovered through the RPS rider. The RPS rider is recovered on an energy basis, and it is not SPS's proposal to change that structure. We are proposing to allocate among customer classes the revenue requirement of the self-built solar projects on a production demand basis. On a jurisdictional level, that would be the 12 coincident peak production demand allocation methodology. On the class level, it would be SPS's proposal is to use the average in excess 4CP production demand allocator. But again, that's just to allocate among customer classes. The rider would still bill on an energy basis.
Okay, so are there any other riders or rates that SPS has in effect now that are allocated based on demand, but then billed based on energy?
Not to my knowledge. This is a function of the structure, the commission structure of the RPS rider, the need to bill on an energy basis.
Gotcha. And the current RPS rider, all of the costs in there are both allocated and charged on a kWh or energy basis, right?
That's my understanding.
Is it SPS's intention to continue allocating that portion of the RPS rider costs on an energy basis?
Yes. And the reason for the difference for these costs, again, is to match the nature of the cost, but also match the allocation of the benefits that would be flowing through to customers through the FPP CAC. And those would be the production tax credits and the investment tax credits, with which SPS has also proposed, and parties do not disagree with the proposal to allocate those on a production demand basis as well. And again, that would be through our fuel factor, which is also typically, energy allocations, but that structure would be a production demand allocation converted to voltage level and then billed through our monthly fuel factors.
Okay, so let's move on and talk about case number 20-00158-UT. Are you familiar with that case?
Not simply by just the case reference. I was doing okay with case numbers today, but I don't have that one.
Well, I'll make it a little easier. Can you pull up OPL Exhibit 5, which is a copy of the final order from that case?
I can and I will. Thank you. I have it here. Case number 20-00158-UT in the matter of commission rulemaking regarding NMPRC Rule 17.9.572, the renewable energy for electric utilities. This order, Mr. McMillan, at least in my copy, looks to be issued December 7th, 2022.
Okay, and so that order came from the Commission's most recent rulemaking on the RPS rule, correct?
I believe this is the most recent rulemaking. I do not believe this is the most recent order.
Your Honor, Could you take judicial notice of the Commission's December 7, 2022 order in case number 20-00158-UT?
Yes, take administrative notice that this is the order issued in 20-00158 UT.
Okay, so generally speaking, Ms. Trammell, in this order, the Commission indicated that it disfavors the use of RPS riders and opened the door to eliminating them on a case-by-case basis, correct?
Again, I don't think this is the Commission's final determination in this rulemaking. I believe there was an order on rehearing that materially changed many of the components that are identified in this final order from both a red line perspective and potentially also from a Commission discussion on the rationale for the changes perspective.
Well, let's look at this order and then potentially your counsel can take you through the other order in a minute. So I want to look at paragraph 164 of that order, which starts on page 78.
Which paragraph again?
164.
Oh, 64. Okay, I have it. I thought you said 174. Apologies.
Oh yeah, no, 164. So in that paragraph, the Commission states, the Commission finds that there are three uncontroverted truths of the IOU's RPS cost riders. First, their RPS cost riders purport to inform customers of the costs of meeting the state's RPS goals, but fail to do so accurately, thereby disseminating misinformation. Did I read that right?
Yes.
Okay, so do you agree with me that if the cost of the self-build solar facilities was included in SPS's RPS rider, and those facilities were not instantly needed to meet the state's RPS goals, that it would move the RPS rider further away from accurately reflecting the cost of meeting those goals?
Can you explain what you mean by instantly?
Okay, so let's say the projects go into service, and on the date the projects go into service, SPS is already ahead of the number of RECs and amount of renewable energy it needs to generate to meet the minimum goals of the RPS. Can you work with me on that hypothetical?
Okay.
Okay, so in that scenario, if the costs of the self-build solar facilities went into the RPS rider, that would mean that the RPS rider was less reflective of the cost of meeting the minimum goals of the RPS mandates in that year.
In that hypothetical example, yes, but I think if the company didn't expect the RECs from those projects to be used for RPS compliance in that particular year, they wouldn't propose the projects to be included for RPS compliance in the rider in the plan filing the year prior.
Well, yes, but correct me if I'm wrong, but it's SPS's request in this proceeding to flow the costs of the self-build solar projects through the RPS rider, regardless of whether the RECs are needed as of the moment of the in-service date to meet the RPS minimums, right?
I would disagree.
Okay, so are you saying that SPS's request is conditional on it needing the RECs from these projects in order to meet the minimum level of RPS compliance as of the in-service date?
I think your question could be overemphasizing minimum, but yes, as we discussed earlier, I think that's consistent with Rule 572 is to recover the costs of compliance through the RPS rider. That's why SPS is proposing to identify the revenue requirement for each applicable rider year in its annual plan and report filing. If the projects are not needed for RPS compliance, again, as we discussed before the break, recovery through the RPS rider is not envisioned by SPS.
Okay, so I think that gives me some clarity here. So in other words, we get to the in-service date of the first two projects, right? And on that date, SPS has or projects that it will have all of the renewable energy generation and all of the RECs that it needs to meet the minimum RPS requirements in that moment. If that's the case, then SPS in its RPS filing would not propose to recover the cost of those facilities through the RPS rider?
From a practical matter, that determination would be made in your example in 2025 at the time SPS makes its plan and report filing for calendar year 2026. But yes,
Okay, and building on that, to the extent that SPS only needed a portion of the production from the self-built solar facilities in order to meet the minimum RPS requirements, then would SPS only flow a portion of the costs through the RPS rider?
no, we would not prorate the revenue requirement. The resource is selected for RPS compliance or not. Similarly, we don't flow through partial PPA costs or partial other costs in the plan years. So SPS would expect to propose the full annual revenue requirement for the facilities needed for RPS compliance in the applicable plan year.
Okay, so taking it out to kind of a admittedly extreme example, in a situation where our SPS needed one REC from these projects, it would anticipate to put the full cost of the projects into the RPS rider?
Yes, without the full project, we don't even get the one REC.
So I'm going to get back to OPL Exhibit 5, which I think you have open in front of you.
Okay.
The Commission's order in paragraph 164 continues, second, RPS riders do not charge customers for all of the costs associated with meeting the RPS, which is a product of arbitrary allocation of renewable energy resources as RPS resources versus system resources. Did I read that right?
Sorry, it took me a minute to find the word second in the paragraph.
Oh, sorry.
Can we start over?
Sure. Are you there now?
Yes.
Okay. Second, RPS cost riders do not charge customers for all of the costs associated with meeting the RPS, which is a product of arbitrary allocation of renewable energy resources as RPS resources versus system resources. Did I read that right?
Yes.
And as we've discussed before, these resources right now are being built as system resources for capacity, right?
That is the primary purpose of SPS's proposals in this CCN case. That's correct.
Okay, and now back to the Commission's order. So finally, in that same paragraph, the Commission says, RPS cost riders are the prime example. And can you confirm that you've found the right spot?
I found and third, yes.
Okay, great. And third, RPS cost riders are the prime example of piecemeal rate making, for which the Commission has a long-standing policy of preventing, but has permitted for reasons that are no longer persuasive and will be exacerbated as utilities acquire more renewable energy assets. Did I read that right?
Yes.
Do you agree that RPS riders are an example of piecemeal rate making?
No.
Okay, if the Commission were to allow SPS to put the self-build solar facilities into the RPS rider, as SPS is proposing, would you agree that it would be to SPS's benefit to seek similar treatment in future CCN proceedings for every new renewable resource it seeks to build?
I do, and I also think it would be consistent with New Mexico's policy objectives to have utilities aggressively pursue clean energy targets and meet ETA compliance.
Okay, and as utilities do that, and as the RPS mandates continue to accelerate, SPS will have a higher proportion and a higher number of renewable resources on its system, right?
Compared to today, yes, I would agree. Over time, I can't say what the exact mix of renewable energy will be on the system.
Okay, would you agree with the commission statement at the end of paragraph 164 that the RPS cost rider, quote, constitutes a separate rate-making mechanism to recover costs that may soon amount to the majority of costs?
That's just a portion of the sentence. I was just rereading the whole piece. I do agree it's a separate mechanism, but I don't agree that it could soon amount to the majority of costs. And I think that's represented by the amount of other resources that SPS continues to demonstrate it needs on its system, most recently, as in SPS's 2023 IRP filing. Yes, we certainly expect a number of low-cost renewable energy resources to be added to our system as our system transitions. But again, the dispatchable need of our system is quite high. Today's dispatchable technologies includes things like combustion turbines and combined cycle gas generations, but also battery energy storage systems. And I believe that the Commission's RPS rule does not consider a battery energy storage system to be a renewable resource.
Okay. And do you agree that as the commission states at the very end of that sentence that I did not read the entirety of, that RPS riders don't address line losses?
I agree that's what this sentence says. I'm not sure I can confirm that the RPS rider does or does not address line losses. The sentence also reads or class allocations, which may be prudent, but again, we've talked about the prudency of determining cost allocations for purposes of many recovery mechanisms, not just the RPS rider here. So it's challenging for me, again, to place myself in the shoes of the commission and agree or disagree with that sentence. I think their context is unknown to me.
Would SPS anticipate addressing line losses in the RPS rider? It's not proposing, but envisioning in this proceeding?
I don't know if we will.
Future?
I don't know if we will or we wouldn't, but in the context of this proceeding, which I think it is important to think about what's going through a cost recovery mechanism and where other components of these projects, both from a cost, say from a DTA perspective, or benefits from an ITC or PTC flowback perspective, it's important to talk about all of our mechanisms. And in the context of the fuel and purchase power cost adjustment clause, we certainly would be incorporating line loss factors and voltage levels into the allocation of the DTA costs through fuel, as well as incorporating voltage levels and line losses into the allocation of PTC and ITC flowback to customers through that fuel mechanism. Again, so there's some context here in the commission's rulemaking that I don't really have. In the context of this proceeding, line loss factors would be handled that way. Class allocations, of course, be handled as SPS has proposed if the commission were to approve our requests.
Okay. Would you agree with me that SPS's current RPS rider does not account for time of use differentials?
I would agree with that.
And on page 44 of your rebuttal, you say that that's appropriate because the RPS mandate exists equally at all hours, so there's no basis to account for time of use in the rider, right?
Can you direct me to a page number?
Page 44.
Thanks. Which line again? Sorry, it's a long Q&A.
One moment, let me pull it up myself. I don't recall the line number. There we go. It's lines 9 through 12. If you could just review those.
Okay.
Okay, so in that portion of your rebuttal, you say that not accounting for time of use in the RPS rider is appropriate because the RPS mandate exists equally at all hours, right?
I mean, that's not exactly what my testimony says, but I'll accept your paraphrase.
But as we discussed before, the self-build solar facilities are not being built to satisfy SPS's RPS mandate in the short term, right? They're being built to satisfy a capacity need.
They're doing both. Primarily, it's a capacity need, but again, our expectation is the RECs will be retired for RPS compliance.
Okay, and capacity needs are driven by demand, right?
Demand and energy requirements on our system, but capacity needs in the context of traditional form is driven by peak demand from a resource planning perspective. I guess I
And
just
demand-
disagree that they're mutually exclusive.
Sure, but demand does vary based on time of day, right?
Yes, it can.
Okay, I'd like to switch gears and talk about kind of a different topic other than the RPS, so we're not beating a dead horse. Let's talk about SPS's proposal to keep 10% of the off-system sales margins from the self-build battery facility.
Okay.
Can you turn to page 52 of your rebuttal testimony?
Let me just move these books around.
Take your time.
Okay.
Okay, so starting on line 3 of page 52 of your rebuttal testimony, you state SPS previously agreed to credit its New Mexico retail customers with 100% of the New Mexico retail portion of the margins from all other off-system sales, starting with the effective date of the base rates in case number 17-00255-UT.
Yes, you
Is
read
that
that
right?
correctly.
And you go on to argue that that's, quote, that settlement stipulation cannot be read to apply to off-system sales from the SPS battery project. The SPS battery project is a BESS resource, which is a new class of resources that the settlement stipulation could not have contemplated because SPS did not operate any BESS resources at that time. Did I read that right?
You did.
Okay, and the stipulation in case number 17-00255-UT, that occurred in 2018, correct?
I don't recall if that rate case was settled or not off the top of my head.
Well, we are discussing here a stipulation from that case, right?
It's discussing a stipulation from SPS's Hale and Sagamore Wind CCN, which is case number 17-00044-UT.
Yeah, my apologies, Ms. Trammell. That is a good clarification. So the stipulation being discussed there from the wind cases, that occurred in 2018.
Yes, looks like February 9th, 2018.
Okay, and in February of 2018, BESS resources did exist, right?
The technology, yes. On SPS's system, no.
And at that point, SPS was certainly aware that BESS resources existed.
Yes, but by no means did the wind settlement include all future generating or other capacity resources on SPS's system. It was specific to the resources at that time and the resources that would be recovered in base rates in that rate case, 17-0255-UT. In other words, the stipulations provision around off-system sales margin sharing did not exist into perpetuity for all new and incremental resources on SPS's system.
Now, I understand that that's SPS's position on what that stipulation means, but the fact is that the stipulation language does refer to the retail portion of the margins from all other off-system sales, and then starting with the effective date of the rates in a particular base rate case, right?
Right. And again, off-system sales related to the assets in rate base in that case.
Well, once again, Ms. Trammell, it doesn't say in relation to the assets in base rates in that rate case, does it?
This sentence does not, but that's the logical conclusion of an off-system sales margin sharing parameter for an existing facility.
Are you aware of any other sentences in that stipulation that refer or limit it to the facilities that were in service at the time of the stipulation?
I don't have the stipulation in front of me.
And I don't have easy access to it either, but are you aware of any particular reference to that in the stipulation?
Not without referring to the document.
Okay, let's get a little bit more into the off-system sales themselves. So
Okay.
SPS has not yet developed a plan for how it would operate the battery facility to balance between ensuring that it's available to serve the capacity need on its system while also optimizing for off-system sales, right?
I disagree.
Okay, well, let's look at OPL Exhibit 12, and that's SPS's response to LES Discovery Request 1-18.
Okay,
Okay, you sponsored that request?
I did.
Or that response, rather? And does that appear to be a true and correct copy of that response?
Yes.
Your Honor, I move OPL Exhibit 12 into evidence.
Request is for OPL Exhibit 12 to be admitted onto the record. Any objection?
No objection.
It is admitted.
Okay, so Ms. Trammell, at the start of that response, you state, SPS has not yet finalized the specific strategy regarding the operation of the BESS, right?
That's correct. You asked me though about distinguishing between serving capacity needs and serving off-system sales, which is different than operating the BESS.
Okay, so are you saying that at this point, SPS has finalized a strategy for optimizing capacity need versus off-system sales?
I'm saying, as is stated in this discovery response, the BESS will be part of the resource stack along with other SPS generation resources, and SPS expects to make off-system sales when the BESS is not needed for load obligation requirements. The resources that SPS submits to the SPP to satisfy its day-ahead and real-time load needs will be dispatched by the Southwest Power Pool. That's what we're referring to when we say part of resource stack.
So at a high level, SPS knows how it will operate the battery, but has it presented a detailed plan for how it plans to accomplish that in this proceeding?
Again, the dispatch of the battery is controlled by the security constrained economic dispatch in the Southwest Power Pool. If the battery is dispatched for SPS's load needs, then that will not be an off-system sale. If SPS's load obligations have been satisfied through the dispatch of other resources, either on SPS's system or in the Southwest Power Pool, the battery could still be dispatched, at which time it would be dispatched as an off-system sale. That is very consistent, if not exactly how other generation resources in the Southwest Power Pool and on SPS's system are dispatched by the SPP.
Okay, and so you're saying that in either case, whether it's an on-system use for SPS's capacity needs or an off-system sale, the dispatch of the battery is out of SPS's hands.
The dispatch directions are given by SPP. It's SPS's responsibility to offer the unit, in this case a battery energy storage system, into the market and to ensure that unit is available for system dispatch if SPP calls on it.
Okay, and has SPS presented a particular strategy or plan for how it would accomplish those objectives in this proceeding?
In the rest of this discovery response, we described that due to the nature of the storage capabilities of the BESS compared to a thermal generator, SPS's commercial operations will employ increased manual operation of the charge and discharge of the BESS to maximize the arbitrage value. There are limitations on the amounts that can be discharged to the battery under the PPA. So within those operational limits, our commercial operations team will ensure the charge and discharge, or work to ensure the charge and discharge maximizes the unit's availability for energy arbitrage.
Okay, and back to my question, is there a specific plan that has been presented as part of this proceeding for accomplishing that objective?
We have not provided another document other than our discovery responses and my testimony on the subject.
Okay, so more generally about the off-system sales margins issue, SPS is proposing to keep 10% of the value of the off-system sales, which means it would capture 10% of the benefit of those sales, right?
Can you clarify what you mean by benefit? I do agree we would retain 10% of the off-system sales amount, margin amount.
Mm-hmm. Yeah, so 10, and by margin you mean profit on the sales, right?
Correct.
Okay, so SPS would retain 10% of the profits from all of the off-system sales from the battery, correct?
Yes, under our proposal.
Okay, so at the same time though, SPS is proposing to recover 100% of the capital cost of the battery from customers, right?
Yes, assuming the commission determines that all invested capital and costs to operate the facility are prudently incurred.
Okay, so under this off-system sales margin sharing plan, customers would bear the full cost of the battery, but SPS would keep some of the value that resulted from the battery.
Yes, and that retention is appropriate to recover or account for the extra work and effort, employee expense incurred to operate that unit in this manner as outlined in SPS's response to LES 118.
Well, to be fair, Ms. Trammell, SPS is already entitled to recover the costs that it incurs to operate its generation resources, right?
Generally, yes, but SPS is not incentivized to optimize the charge and discharge nature of this asset.
Is it SPS's position that it will not strive to optimize the charge and discharge of this asset absent an incentive?
No, it's SPS's position that it is reasonable and in the public interest to have a balance here of incentives and benefits from this type of operation of a battery energy storage system, given its available arbitrage value that can be harvested if the unit is operated that way.
Is it fair to say that SPS's obligation to its customers includes prudently and efficiently managing its system?
Yes, of course.
And would you agree with me that any resource that's offered for off-system sales requires time and attention and employee effort on SPS's part?
Yes, but the battery is a little bit different in the sense that we have to decide when to charge it. So to compare to a thermal unit, we decide how to operate the unit and how to maintain the unit to make sure that it's available. Here, we're making conscious decisions of, is this the right price in the market to now charge this battery? And that takes an assessment of, will energy prices be lower, tomorrow or next week? Should we be charging the battery at this time to maximize the value of energy arbitrage of this facility. That's quite different than the availability activities that SPS employs to ensure its thermal fleet is available, both for load serving obligations as well as off-system sales opportunities.
Okay, and to be clear, Ms. Trammell, those activities that you described of like when to charge and when not to charge the battery, and making those decisions is something that SPS is going to have to do regardless of whether it gets any percentage of the off-system sales margins, right?
Yes.
That's all the questions I have for this witness right now, Your Honor, and I'll pass her for cross-examination by other parties.
Okay, thank you. I have 11:20, so I think we'll be able to continue with NMLCG, who requested 45 minutes. Do you have any constraint? Do you have any constraints to limiting those times to before noon?
No, I think we should be able to conclude before noon just fine.
Okay.
Thank you.
Proceed.
Good morning from Denver. Good afternoon where you are, Ms. Trammell.
I think it is good afternoon from Austin. Hello, Mr. Stoffel.
For the record, I'm Nick Stoffel. I'm one of the attorneys representing the New Mexico Large Customer Group in this proceeding. Today, I would like to have a discussion with you regarding the federal tax credits applicable to the proposed solar and battery storage system in this proceeding. And let's start with production tax credits, or PTCs. PTCs are generated by renewable generation produced and sold by the taxpayer during the taxable year, and the PTC is available for 10 years after the generation facility is placed in service. Is that right?
That's my understanding on based on current federal tax reform.
And so you agree that the amount of PTCs from an eligible renewable generation facility depend on the amount of kilowatt hours produced by that facility during a 10-year period, right?
Yes.
And SPS proposes to credit customers for the PTCs from the solar projects through the Fuel and Purchase Power Cost Adjustment Clause, or FPPCAC, right?
Correct.
SPS currently has wind facilities that are generating PTCs, correct?
Yes.
And the PTCs from those wind facilities are currently credited to customers through the FPPCAC, right?
They are. I'll just note they're also grossed up for income taxes, but yes.
And those wind facilities were constructed as part of Xcel Energy's Steel for Fuel strategy. Would you agree with that?
I would.
And the idea was that the wind facilities would reduce fuel costs, right?
Yes, through the avoidance of energy costs incurred, as well as the receipt of federal production tax credits, which both, as you noted, go through SPS's fuel clause.
And the solar facilities proposed in this proceeding are also expected to reduce fuel costs, correct?
Yes, in both of those reasons, avoided energy costs and the receipt of production tax credits.
And the fuel savings and amount of PTCs both depend on the amount of energy produced by the wind or the solar facilities, right?
Yes.
So you would agree that there is some nexus or connection between the benefits from the wind and solar generation facilities and the fuel costs recovered through the FPPCAC, right?
Some.
Now, one of the new benefits for PTCs under the Inflation Reduction Act is the ability for SPS to transfer or sell those tax credits to another taxpayer, right?
To be clear, we're not selling those tax credits. We're not selling customer value of tax credits. We're selling or potentially transferring unused tax credits that SPS is, as a taxable entity, not able to utilize in a particular tax year. So I just want to create two very distinct pictures of tax credits. There's a customer portion that flows through under our proposal to fuel, either the production tax credit from the solar or the investment tax credit from the battery. That is separate and distinct from unused tax credits on the company side that would be subject to the transferability provisions of the Inflation Reduction Act.
And so let me make sure we're on the same page. I think we are, and I think it's a good thing to clarify. So your point is that with transferability, that does not diminish the amount of tax credits that customers will get credit for. Is that what you're saying?
Correct.
So recognizing the transferability option is new, let's talk about some of the details about how you expect that will work. The credits are transferred on an annual basis and can only be transferred once, correct?
I believe you're referring to a section of my direct testimony that outlined some of the IRS guidance at the time the direct was filed. Would you mind if we went there?
That's fine. Yes, I'm referring to page 79 of your testimony, page 86 of the PDF of the exhibit.
Thank you.
And so I'll direct your attention to line 12. And my question was, the credits are transferred on an annual basis and can only be transferred once, right?
Sorry, I'm still getting to the
Oh, you're
page.
fine.
Can you tell me the page again? Was it 79? Okay, there we go. I'm there.
Line 12.
Yes. The credits may be transferred on an annual basis, but they can only be transferred once, meaning an entity who the credits are transferred to cannot transfer them again.
And for each taxable year, project owners like SPS must make an election on a facility by facility basis to transfer any portion of the credits earned by each facility, right?
Yes. And to be clear, it doesn't say that, but given my prior compartmentalization of the customer tax credits and unused tax credits by the company, it might be best to say to transfer any portion of unused tax credits earned by each facility.
Okay.
I think you can understand the distinction.
And make sure we're clear, when you say unused, you mean not used by SPS to offset its tax liability, right?
That's correct.
Okay. And the buyer of these unused tax credits must pay cash for the credits, and the transfers are not taxable, right?
Yes, that's number 5.
The actual sales of production tax credits for cash payments will be limited to the production tax credits actually produced each year of the applicable 10-year period, right?
Are you referring to my testimony for that one?
I'm just essentially asking you, you agree the company will not be able to sell more production tax credits than it actually produces from its facilities, right?
I agree. In a particular year.
Turning to the other type of federal tax credit involved in this proceeding, which are investment tax credits or ITCs. Unlike the PTC, the ITC does not depend on the actual output of the underlying generation or storage facility over a period of time, right?
That's correct.
Instead, the ITC is based on a percentage of the investment in an eligible asset, right?
Initial investment, yes.
For the proposed BESS, that's the battery storage system, the ITC is equal to at least 30% of the capital investment in the BESS, right?
That's correct.
And it's potentially worth up to 40% of the investment in the BESS if certain criteria are met, correct?
Yes.
So for a capital investment in a BESS worth approximately $64,242,722, as proposed here, the company estimates that the ITC is worth about $25.1 million after accounting for transaction costs and the income tax gross up, right?
Those numbers sound very familiar, subject to check with Mr. Fetters. I'll accept those to be correct.
So, and I'll say that was from Mr. Lytall's direct for the battery cost, and Mr. Fetters had provided the value of the ITC. So, but you accept those subject to check. Thank you.
Mr. Stoffel, I would just clarify the difference between the costs of the project included in Mr. Lytall's testimony compared to Mr. Fetters' are changes in the AFUDC calculation, which Mr. Fetters discusses.
And I appreciate that clarification. Do you know, does the company get any ITC for the AFUDC associated with the battery?
It gets an ITC based on the invested capital. So AFUDC is no longer accrued once the construction project is placed in service. So AFUDC becomes invested capital when the project is placed into commercial operation, or that amount is transferred from the construction plan account to plant and service.
But do you know whether you can get a 30 to 40% ITC for the amount of the AFUDC associated with the project?
For a utility like SPS, yes, AFUDC would be included in the invested capital amount once the project is closed to plant service.
So if SPS transfers the ITC to another taxpayer, then the purchaser receives the full value of the ITC in that year, and SPS will receive a full cash payment for the ITC in that year, right?
Yes, the full ITC can be transferred in the first year because it is received by an entity like SPS upon the project going into service.
So the full value of the ITC and the cash payment to SPS for the ITC, if it's transferred, will be known at the time of the transfer, right?
Presumably, again, assuming that SPS cannot use those tax credits in that first year. In your example would be at the time of the transfer, implies that SPS is unable to use those tax credits in year one of the battery.
And the company's position in this case is generally that it will not be able to use the tax credits associated with the solar and the battery storage projects proposed here because you are in a net operating loss position and expect to be going forward, right?
I would say the company's position is, to the extent we are in a position that we're unable to use the tax credits, we intend to transfer them.
And it's the company's position that one of the benefits associated with the ability to transfer PTCs and the ITC under the IRA is the opportunity to avoid a deferred tax asset, or DTA, correct?
That's correct.
If we could take a look at NMLZG Exhibit 2. And so this is SPS's response to OPL 13. Do you have that available?
You said LCG2.
Yes.
You're high on the list for the most acronyms in one sentence, I think, Mr. Stoffel, so it's taken me a minute.
Thank you. I defined a new one in that last question even.
OPL 13.
Correct.
I'm there.
Thank you. You're a sponsor of this response, right?
I am.
I'd move to admit NMLCG Exhibit 2.
Request is for NMLCG Exhibit 2 to be admitted onto the record. Any objection?
No objection.
It is admitted.
So subpart A asks how SPS will determine whether a tax credit transfer is more cost effective for customers. Do you see that?
I do.
And the company's response says, SPS will compare the carrying cost of a tax credit related to deferred tax asset versus the cost of transferring the credit. SPS anticipates that for the foreseeable future, a transfer will be more cost effective because the monetization of new tax credits will be delayed as SPS continues to utilize its existing deferred tax assets. The carrying cost of an asset can continue for multiple years, while a transfer cost is a one-time occurrence. Thus, if the utilization of a tax credit is not anticipated to be near immediate, a transfer will be the more cost-effective option. Is that right?
Yes.
To summarize the company's position, due to carrying costs, it can be more cost-effective to receive cash immediately for less than the full value of the tax credit than it would be to receive the benefit of the full tax credit in the future. Is that right?
To be clear, the beneficiary in your context is the customer. But yes, I agree with your sentence.
I guess with tax credits, there's multiple beneficiaries, right? There's the customers receiving the benefit in rates and the taxpayer receiving the benefit against their tax liability, correct?
Again, the importance of compartmentalizing the customer value of PTC and ITCs and the company's unused tax credits. Transferability is a benefit for customers only.
Okay. Looking at your direct testimony, SPS Exhibit 2, page 79 of the PDF, page 72.
Slow down. 79 of direct?
Page 72 of the actual page numbering of your testimony.
Okay. I'm there.
Look at line 6, please.
Okay.
There you testify that given the formation of a DTA is directly correlated to the actual output of an eligible generation facility, it is appropriate for SPS to credit tax benefits to customers, recover the return on a DTA, if any, and recover the newly established tax credit transferability expense through FPPCAC rather than base rates, right?
Yes.
The formation of a DTA associated with an investment tax credit is not directly correlated to the actual output of an eligible facility, right?
I would agree with that.
Instead, whether SPS records a DTA associated with an ITC depends on whether the company can sell the entire ITC that it cannot use to another taxpayer in the tax year the ITC is created, right?
Can you say that again?
Whether SPS records a DTA associated with an investment tax credit that it cannot use depends on whether the company can sell the entire tax credit to another taxpayer in the tax year the ITC is created, right?
I'm not sure. We can certainly sell all of the tax credit. I'm not sure if we can sell a portion of it. So it's hard for me to answer your question. I'm not sure if we could sell, even though we earn the entire ITC in a particular year, and we could certainly, if unused and somebody wanted to buy the entire ITC, transfer the full amount. But I'm unable to say yes to your question, Mr. Stoffel, because as I stand here today, I don't know that we can or cannot transfer a portion of the ITC in the year it's received.
But and my question is less about whether you can transfer all of it or a portion of it, but the creation of a DTA is associated with the company retaining some portion or all of a tax credit that it cannot use in that tax year, right?
I disagree. Really, the creation of the DTA is a function of us crediting customers the value of the PTC or the ITC in your example much faster than SPS would be receiving the benefit for. So again, in our case, we're proposing to flow back the ITC and PTC through fuel. For the PTC, it would be as generated through our monthly fuel factors. For the ITC, we've taken a similar approach on an amortized basis through the fuel factor, so that receipt of benefits to customers can be as timely as possible. If we were holding the receipt or the flow through of the ITC on the customer side of this equation for longer, and we were not returning the value to customers until SPS could use the tax credit against their taxable income or transfer, there would not be a DTA. So it's less about how you characterized it and more about the difference in timing between when we're flowing back the benefits to customers and when we SPS as a taxable entity are able to utilize the tax credits for our income tax expense.
So you're getting to the fact that SPS uses normalization for rate making instead of flow through. Is that what you mean?
No, I'm getting to the fact that a DTA wouldn't exist if we weren't immediately passing through the value to customers.
Immediately passing through the value to customers. So according to your testimony, flowing all aspects of tax credits through the fuel and purchase power cost adjustment clause benefits customers by ensuring timely receipt of the overall value, right?
That's correct.
And the company is proposing to flow the benefit associated with the ITC over a 5-year period, correct?
Yes, through an amortization.
But the company will receive an entire cash payment for the ITC in a single year, correct?
Yes, assuming we qualify, which we expect to do.
So under SPS's proposal, there is a timing mismatch between SPS will receive the cash payment for the ITC and when customers will receive the overall value of the ITC, right?
I agree with the difference in timing of the cash payment and the flow through, but again, that's not a dependent or an interdependency of the DTA.
Assuming the ITC is transferred as SPS believes it will be, SPS will have received capital for the ITC to offset its capital investment in the battery storage system, but it is not proposing to add the net amount, gross investment less ITC, to rate base, correct?
I don't know that we'll record the ITC received as a capital offset. I don't think that's the accounting of the ITC.
And my question was not about the accounting for it. It's that you will have paid the capital investment, you will have made the investment in the storage, you will have earned an ITC. The company expects to sell that ITC for cash, and you are not proposing to add the net amount to rate base, correct?
No, that is not our proposal.
SPS proposes to recover carrying costs on the entire investment in the battery storage system, correct?
In rate base, invested capital earns a return on established by the commission through a weighted average cost of capital. It is like a carrying cost. It's not often referred to as a carrying cost, though I would say a weighted average cost of capital is what would be applied to SPS's invested capital for the battery.
The same carrying cost the company proposes to apply to any DTA, correct?
Correct. And the same carrying cost that the commission's RPS rule spells out is to be recovered on any deferred renewable energy expenses.
And so SPS is proposing to recover the weighted average cost of capital on the entire capital investment in the battery storage system, despite receiving a cash payment for an investment tax credit reflecting approximately 30 to 40% of that investment, right?
Again, the value of the ITC goes back to customers through fuel. So it is true that we're not going to be reducing the revenue requirement or the rate base amount of the invested capital for the battery, but the value of the ITC, the value of the customer's value of that cash payment under SPS's proposal would be received by customers as an offset to eligible fuel expense in the FPPCAC.
Under the company's proposal, correct?
Yes.
And the parties do not necessarily agree with that proposal, correct?
I think parties have taken varied positions, some in support and others not in support. But I think everyone generally agrees that the tax savings of these projects, both the solar and the battery, should be flowed back to customers as timely as possible upon commencement of recovery.
As timely as possible. And a timely way to provide customers the value associated with the tax credit would be to reduce the rate base amount from the first time it goes into rates, correct?
I disagree. I think flowing the ITC back through fuel is more timely than waiting for a rate case.
Customers would not be paying for the cost of the battery until you file a rate case, correct?
That's true because it's conditioned on commencement of recovery, but the timeliness of the FPPC AC flow through would better match the amortization that the commission determines in this proceeding.
And the commission could also determine in this proceeding or a future rate case to apply the investment tax credit to reduce the rate base amount so customers do not pay a carrying cost on 30 to 40% of that investment for the life of the investment, correct?
Again, I'm not sure that would be the proper accounting. And I know you're asking about the regulatory treatment, but it's important that we not lose sight of the regulatory accounting treatment of the ITC. And I don't believe that's the way the ITC would be recorded by a rate regulated utility like SPS. Now, other entities that are eligible to receive or qualify for an ITC, that may be well how their accounting works. I do not believe that's how our accounting is meant to be incorporating that ITC.
And so back to my question though, that is a way the commission could decide to treat the investment tax credit for rate making, correct?
I disagree. I don't think that's a proper methodology for a rate regulated utility.
And are you saying the commission does not have the authority to do that?
The commission can determine its authority. I'm saying I don't agree that would be a reasonable determination for a rate regulated utility.
So you would agree opinions could differ as to the appropriate rate making treatment, and the commission would have to decide which approach to adopt.
Based on the evidence in this case, and I don't think that is, again, a reasonable methodology to be used by a rate regulated utility.
In this case, or just in whichever case the commission decides to approve rate recovery for the battery storage facility?
Preferably, I believe in this case, again, since we would need to be accounting for this project upon its approval as well as through its in-service date.
Preferably, but not necessarily, correct?
From a accuracy of utility accounting, I'll stick with preferably.
Thank you, Ms. Trammell. I have no further questions, Your Honor.
Thank you, Mr. Stoffel.
Thank you. I have 11:47. Our next, probably gonna cut it too close here. Our next request is by LES for 20 minutes. LES, are you comfortable beginning, or would you prefer to go once we get back from lunch?
I can make things much easier for you, sir. All the questions I have for this witness have already been addressed. So I don't need any cross-examination at this time.
Okay, thank you.
Thank you.
Department of Justice and CCAE have asked for additional time. Mr. Bogatko, you requested 20 minutes.
That's correct.
Do you feel you could get those in before lunch if I put you now, or what would be your preference?
Oh, do you mind if I go after lunch, please?
Sure, no problem.
Thank you.
Okay, let's go ahead then and take our break for lunch. I have 11:48, but I'll give us the opportunity to take a full lunch here. Let's go on. We'll come back and we'll start with Department of Justice, CCAE, and then staff. Once we come back, but let's go ahead and take our lunch break until 1 o'clock. Allison, anything that's needed by you?
No, Mr. Hearing Examiner, thank you.
Okay. Then let's go ahead and go on break, and we'll come back on the record at 1 o'clock. All right, I have 1 o'clock on my phone, so let's go ahead and get everyone back. Madam Court Reporter, we ready to go back on the record? Indeed. All right, we are back on the record, resuming witness Trammell for SPS. Next request I have for cross-examination is New Mexico Department of Justice. So please proceed with your cross-examination.
Thank you, Your Honor. I'm not seeing, there you are, Ms. Trammell. How are you today?
I'm good. Ms. Barrett, how are you?
I'm good. I don't think we've met before. I newly joined the New Mexico Department of Justice, formerly the Office of the Attorney General. You won't be quizzed on which one you use. It's a grace period for that, so either one is fine. To start, I wanted to let you know I'm going to be using a lot of the same abbreviations that the other interveners used this morning and make sure that's okay. ITC, PTC, BESS,
Yes.
things like that.
Yes, ma'am.
Okay. And I'm also going to be jumping between your direct and rebuttal testimony quite a bit. So if you wanted to have those prepared.
Okay. Yeah, I have both with me.
Great. So to begin, could you please turn to page 35 of your direct testimony? And we're going to be looking at table BAT5.
Okay.
This table shows the total estimated cost of the solar projects and the BESS, and it's 768.426 million. Is that accurate? Give or
Yes.
take? Okay. And that's a total company amount that includes both the New Mexico and Texas costs. Is that correct?
Yes.
So if you flip now to the bottom of page 48 of your direct and moving over to page 49 is when you begin a discussion of the PTCs and the ITCs. Let me know when you're there.
Okay.
So on page 49, right at line 1, you state that the PTCs are expected to be around 494 million, and that is on a total company basis. Is that correct?
Yes, that is on a total company basis.
Great. And then moving down to line 8 of that same page, you state that the ITCs are expected to be around 25 million total company.
Yes.
Okay. Would you agree that the availability of the PTCs and ITCs has a significant impact on the costs that are ultimately charged to ratepayers for these projects?
Yes, a positive impact.
Okay. So also on page 49, starting at line 11, we talk about the fact that the PTCs and ITCs can be sold or transferred now as a result of the Inflation Reduction Act of 2022. And as you discussed in the application, the company, we already talked about this, you're intending to sell or monetize the tax credits, yes?
The unused tax
The
credits.
unused, right. And the reason the company plans to sell the unused tax credits is that it can't use these tax credits itself right now. Is that correct?
The main benefit of transferring the unused tax credits is to reduce or avoid accumulation of the deferred tax asset balance. So that is the primary reason we will pursue transferability, is to, for customers' benefit, avoid the accumulation or the growth of a DTA balance over time.
Okay. But it's true, is it not, that the company is planning on selling these tax credits in part, at least, because they are not in a position where they can be used immediately?
I mean, that is a requirement of the transferability framework, but our intention to transfer is to secure the customer savings.
Okay. The amount of the PTCs is based on the amount of energy that's actually produced over the first 10 years of the operation. Is that correct?
That is correct. It also has I think, an inflation escalator over time, but it is a function of output produced at the qualifying facility.
Okay. How long does the company have to utilize each year's PTCs? Is there a time limit?
In the context of offsetting federal tax expense or transferring unused tax credits?
I would
when you say use.
I would say both. Does the IRS put a time limit on how long you can use these to offset taxes? I guess first.
I'm not aware if there's a time limit or not on how long a company can hold unused tax credits for future use. In terms of transferability, it's my understanding that the entity who is transferring or selling the tax credits needs to transfer the credits before it files its tax return for the applicable production year. So for example, if an entity like SPS files its tax return in October, we would need to transfer any unused credits for the prior year by October of the following year.
Okay, that makes sense to me. And then moving on to the ITCs or the ITC, are these available to be used by a company upfront once the eligible project is operational? Am I understanding that correctly?
Yes, that's my understanding as well, that once the project is in service and the project qualifies, the ITC is received by the project owner.
Okay. And similar to the question I asked about the PCCs, do you know if there is a time limit on either when they can be used to offset or when they can be transferred?
I believe it's the same. My answers would be the same. I'm not aware of an ITC limitation on how long we can hold, and the transferability framework is the same for whether it's a production tax credit or an investment tax credit.
Okay. If the company does not monetize the PTCs and ITCs, is there any current estimate for when SPS would be able to begin to utilize the PTCs and ITCs to offset its federal taxes?
If we're not monetizing, we're not using. So do you mean if we're unable to monetize or use, when might we be able to transfer?
No, I think I said just the opposite. If
okay. Sorry about that.
Is there an estimate? As I understand it, SPS is not in a position where they are going to be using these tax credits to offset their federal taxes right now, because there's a backlog of credits. Is there a current estimate for when SPS would be able to begin to utilize these tax credits to offset its federal taxes? Does that make sense?
It does. And I apologize for misstating the question back to you incorrectly. I'm not aware of when that time frame would be. We do have, as you mentioned, have a backlog, as you stated. So I don't know exactly when we would be able to start utilizing. Obviously, many factors would influence the timing of that utilization.
Okay, thank you. Am I correct that SPS files its federal income taxes as a part of a consolidated income tax return?
Yes.
And the tax federal return includes all of the Excel companies, is that correct?
Yes.
Approximately how many different companies are included in this consolidated income tax group?
I'm not sure.
Do you know whether it includes both regulated and non-regulated companies?
It may.
All right. So in a consolidated income tax group, the IRS allows taxable losses experienced by one of the consolidated group members to be used to offset the taxable income of another group member. Is that correct?
I'm not sure.
Okay. And similarly, you may not know this, can tax credits generated by one member of Excel's income tax group be used to offset the taxable income of the entire consolidated group?
I'm not sure.
Okay. All right, so going back to your direct testimony, if you can turn to page 80, please.
I'm sorry, which page?
Page 80.
Okay.
All right. Starting on line 12, you discuss two types of costs that are going to be necessary to monetize these tax credits. According to your testimony, there's likely to be a discount to the face value of the tax credits that are sold, and also likely to be administrative or transaction costs incurred. Is that accurate?
Yes.
Okay. Under the company's proposal, the full value of the tax credits would be passed through the fuel clause as a credit to fuel, and then there would be an expense to ratepayers to pay for any transaction costs or discounts associated with the sale of the tax credits. Am I understanding that correctly?
And assuming transferability, there's a third leg to that stool, if you will, of the DTA balance that does not accrue.
DTA balance. Okay. And in its proposal, SBS is proposing to recover that shortfall that consists of the administrative costs and the discount to the face value from ratepayers through the fuel clause. Am I understanding that correctly?
Yes, we would record those transaction costs or administrative costs as income tax expense, and that would be a line item added to SPS's 550 fuel reports so that we could bring in those actual transaction costs into our monthly fuel factors.
Okay. So I have a couple of questions for the process, about the process for selling the tax credits. SPS's revenue requirement model here is in part based on the assumption that SPS would sell all of the PTCs and ITCs associated with the projects. Is that accurate?
That is how we've modeled the revenue requirement and the transferability provisions in this proceeding, yes.
Okay. And on what information is that assumption that you'll be able to sell all of the tax credits based?
It's based on our judgment in the market. Our tax department sees a demand for tax credits from third parties that's roughly 10 times the amount of tax credits that would be eligible from the regulated utility industry as a whole. In other words, the demand for tax credits from third parties in this transferability market far outweighs the available tax credits that the industry, not just SPS or utilities in New Mexico, but the electric and utility industry in the nation is expecting to have in the future.
Okay. And then this is just a technical question. The third parties that you're talking about who could potentially, to whom these tax credits could potentially be sold, is it just other utilities that would be eligible, or does the market consist of entities that are not public utilities or not electric companies?
The latter. The market includes non-affiliated third parties from across the economic sectors in the United States.
Okay. Currently, is there a central market for tax credits? Or does each deal have to be negotiated separately between SPS and a potential buyer?
There's not a market platform, if you will. I think maybe some could be set up in the future, but our expectation is that Xcel Energy would sell or transfer unused tax credits from our operating companies, including SPS, through bilateral contracts.
Are you aware of any of these kinds of tax credit sales that we're talking about that Xcel has made since the IRA was passed? I guess, is SPS currently engaged in this kind of selling process? I'm sorry, Xcel, not SPS. Sorry.
I understand. We are at Xcel, not for SPS unused tax credits, but it's my understanding we have marketed and sold unused tax credits in one or more of our other regulated operating companies. Again, not SPS, not Texas, New Mexico, but one of the other four Xcel Energy operating companies.
And would you know, as you say here today, whether those other Xcel companies were able to sell all of the tax credits that they intended to sell?
Mr. Examiner, I'm going to object to these questions. I think they're outside the scope of Ms. Trammell's testimony with respect to what other Xcel companies are doing.
Is there a line to this particular application with this line of questioning, Ms. Barrett?
I mean, Your Honor, that was basically the end of the line of questioning. Ms. Trammell says several times in her testimony that SPS expects that it will be able to sell all of the tax credits. And I'm just trying to get a sense of whether they are basing that on some sort of knowledge inside of the company where they've done this before and can make that kind of assumption, because it is an important part of their proposal.
Okay, I mean, to the extent that we want to cover I mean, I think you can simplify that by basically asking her, is it their position? I don't think we really need to delve into what the other ones are. So for that portion of it, I'll maintain the objection. But if you align your questioning to kind of what you just told me right now, is it their statement? Then I'll allow the question.
Okay. Is it the company's position that based on credible information, they will be able to sell the entirety of the tax credits that are being contemplated here?
You're asking about SPS now, not
Yes,
the
ma'am.
other opcos?
Yes, ma'am.
Yes, it is our intention to transfer all unused tax credits that we have available to market.
Okay, and let's move on. So I want to talk a little bit about the carrying costs that you discussed in your pre-filed testimony.
Okay.
In addition to charging ratepayers for discounts and transaction fees that are associated with tax credits that are sold, SPS is also proposing to charge ratepayers a carrying cost. Is that on any of the unsold tax credits? Is that an accurate reflection?
Yes, if a DTA balance accrues,
Mhm.
SPS would continue to record a WAC return on that, similar to how it does the deferred tax asset associated with PTCs from its existing wind facilities.
All right. And under the company's proposal to recover the revenue requirements, excuse me, through an annual rider, SPS would not have to wait for a base rate case to start charging these carrying costs. Is that correct?
Our proposal is to recover the return on the DTA, again, if there is a DTA balance, through the fuel and purchase power cost adjustment clause.
So assuming that there are unused tax credits, there is a DTA, there will be carrying costs. How long would ratepayers continue to be charged the carrying costs on these unused credits?
In that hypothetical, so long as the balance accrues on SPS's books and records.
So long as the balance accrues, is there any plan to have any kind of an annual amortization associated with the tax credits? Meaning if they're not sold, does the balance get reduced each year? Or does the original cost just continue year after year indefinitely?
Sorry, can you ask that again? I'm not following that question.
So say we're talking about, it's way oversimplified, but $100 of tax credits that were unused and put into this DTA. Is there any kind of an amortization that are going to be associated? Meaning, does the balance get reduced each year, or does that original 100% just continue year after year indefinitely?
That might be a better question for Mr. Fetters.
Okay. All right. Could you please pull up NMDOJ exhibit number 5, and this is SPS's response to NMAG 2-09.
Okay, I have it.
You're faster than me. Hold on a sec. Does this look to you to be a true and correct copy of SPS's response?
Yes, it does.
Mr. Hearing Examiner, I'd like to move for admission of NMDOJ exhibit 5 to the record.
Request is for NMDOJ exhibit number 5 to be admitted. Any objection?
No objection.
It is admitted.
Thank you. Am I correct that prior to SPS's last rate case, which was 22-00286 UT, SPS had net operating losses that prevented it from using the tax credits that had been generated by Hale and Sagamore, as you discuss in Part A of this response.
Yes.
And in the same last rate case, SPS assumed that any net operating losses would be used up by the future test year, which I believe was 12 months ending June 30, 2024. Is that accurate?
Yes, that's the future test year end.
And is it also true that the company assumed that any net operating losses would be used up by the end of that future test year?
You might check with Mr. Fetters. I don't recall.
Okay. So as we were talked about briefly before, SPS now has a backlog of PTCs from Hale and Sagamore and will have accelerated depreciation on the solar projects. So it will not be able to use the PTCs and ITCs that are generated by these new projects being proposed in this case. And as I'm quoting from your response now, for several years after the projects come online. And that's a quote from Part A, and I just want to make sure that I'm understanding that in the context.
Yes, that is the response in subpart A, and that is the context to the extent that other tax credits need to be utilized first. That would extend the time period in which tax credits from the solar projects would be monetized or used by SPS to offset its tax liability.
Okay. So am I understanding correctly that the IRS requires SPS to use the Hale and Sagamore tax credits first before it can use any of the tax credits, the potential tax credits generated by the solar projects and the BESS in this case?
Certainly the IRS hasn't weighted on specific projects, but I think the older tax credits need to be utilized before the newer tax credits.
Okay, that makes sense. Even though SPS has these unused tax credits, customers are paying for federal income taxes associated with the revenues and expenses authorized by the Commission in its last base rate case. Is that correct?
Yes, as we discuss also in subpart B of this response, the Commission has consistently instructed utilities to calculate for cost of service purposes a standalone tax calculation in base rate case proceedings.
Okay, thank you. If you could turn to what has been marked as NMDOJ exhibit number 3.
Okay.
This is exhibit D, which was an attachment to the stipulation in the 2022 286 UT rate case. Does this look like an accurate representation of that exhibit that was an attachment to that stipulation to you?
It does, but I can tell you that Mr. Fetters will be much more familiar with this document than I am in its detail.
Okay. So, Your Honor, can I request that the Commission take administrative notice of NMDOJ Exhibit 3 since this is an attachment to a public document while we have it up?
Any objection, Ms. Hardy?
No objection.
Okay, I'll take administrative notice of it.
Okay. Give me just a second. I want to look at my questions and see what would be, I don't want to waste time, so. Okay. I am going to reserve my questions about that exhibit for Mr. Fetters, since you already told me that that would probably be a better use of time. So let's go back to exhibit 5, which is what we were just looking at. That's the discovery response.
Okay.
To NMAG 29.
I have it.
Part B, you say that the Commission has consistently approved SPS calculating its income taxes as if SPS were a standalone company, which is what you were just saying before we jumped to the other exhibit. Is that accurate?
Yes, ma'am.
All right. Given this standalone treatment for rate-making purposes in the last rate case, the commission could have utilized some of the Hale and Sagamore tax credits to eliminate the future test year income tax expense for rate-making purposes. Is that something that you could confirm, or is that better question for Mr. Fetters?
I would direct that to Mr. Fetters.
Okay. Can you please pull up NMDOJ exhibit number 6?
Okay.
And this is the stipulation in case number 17-00044-UT.
I agree.
All right. So if you look at page 15 of this document, there's no Bates numbering, so it's just the number on the bottom of the page.
Okay.
Subsection E. There is a provision that requires SPS to remove all PTCs from rate base by January 1, 2026 if the amount exceeds 400 million on a total company basis. Is that an accurate statement?
We're really removing the deferred tax asset balance.
Yes, ma'am.
Functionally, that's the header of this section, but yes, I agree. That's the provision of this part of the stipulation.
All right. Do you know the current balance of the unused PTCs associated with Hale and Sagamore?
I suspect it's on those rate-based detail schedules, but again, I think Mr. Fetters is more familiar with those balances than I am.
Okay. Do you know if the company plans to file a base rate case to remove these PTCs from rates? And if so, when does it expect to make that filing?
We're not expecting to file a rate case for that purpose.
Okay. Turning to your rebuttal testimony, page 24.
Okay.
So starting on line 10, it states SPS must record a DTA to account for the unused federal tax credits that SPS cannot transfer due to generally accepted accounting principles and for accounting rules. Is that correct?
That line item doesn't say exactly what you said after the sentence, but yes, those are the reasons that my rebuttal testimony addresses why we need to appropriately record a DTA, again, if we're unable to transfer unused tax credits at SPS.
Okay. And the rules that are cited in footnote 48 on this page, do these rules require a regulatory commission to include carrying costs on the DTA?
I'm not sure.
Can you pull up NMDOJ exhibit number 4, please? And this is a response to OPL 37 in this matter.
Okay.
Does this look like a true and accurate copy of SPS's response?
It does.
Hearing examiner, I'd move for admission of NMDOJ exhibit 4 to the record, please.
Request is for NMDOJ exhibit number 4 to be admitted. Any objection?
No objection.
It is admitted.
Thank you. Looking at part B of this response, am I correct that it indicates that the commission is not required to apply carrying costs to the DTA?
Not required by financial reporting standards. That's correct. We do cite several New Mexico statutes and commission rules that provide for the commission setting just and reasonable rates.
Okay.
But yes, we are not required by the ASC. Thank you for refreshing my memory.
Sure, of course. Moving on. I have a few questions that are specific to the ITCs. The company is proposing to credit the fuel clause with the ITCs. Is it over a 5-year period?
Yes, we are proposing to flow back to customers the value of the ITC grossed up over a 5-year period, that amortization. Could be a different number, but SPS's proposal is 5 years.
Okay. And then going back to your direct testimony, page 78, please.
Okay.
You discuss that if certain conditions are met, the ITCs could be increased from 30% to 40%. At this point, does the company know whether the BESS will qualify at the 30% or the 40% level?
We do know that it can qualify for the 30%. The 40% would be indicative of earning the energy community bonus. That'd be the additional 10% ITC value on top of the 30. And it's my understanding our ability to definitively determine whether or not that additional 10 percentage points would be attributed to this project. It won't happen until much closer to the in-service date.
What is the process that the company needs to go through in order to get that determination nailed down?
I don't think it's a process that we go through. I think it's a process the Internal Revenue Service goes through.
And when you say much closer, any ballpark of how much closer it will know whether or not it's going to get that extra 10 percentage points?
I don't know definitively. I think, for example, the IRS evaluates certain rates and economic conditions in energy communities at the time of the in-servicing of the project.
Okay. If you could go to page 34 of your rebuttal, I'd like to talk a little bit about the RPS rider.
I'm there.
Okay. On page 34 is when you discuss the fact that SPS is proposing to recover the revenue requirement associated with these projects through the RPS rider. The company is also proposing specific depreciation rates and a methodology to allocate costs among various customer classes. That's correct?
Yes, and just to clarify, it's the solar project revenue requirement being requested to recover through the RPS rider, not
BESS.
all the self-builds.
Okay, thanks for that clarification. If the costs are recovered through a rider, would the commission retain the ability to change the depreciation rate and class cost allocation methodology in the future?
I think it could. I think it depends also on how the commission orders those items in the CCN proceeding. And I say that given Rule 572, I'm sorry, not Rule 572, the CCN statute, subpart B that we were looking at earlier this morning makes reference to if certain rate making provisions are requested by the utility applicant, the commission is to outline, I believe it says shall, the commission shall outline the applicability of those rate making frameworks and decisions and their applicability in future cases. So for example, our expectation would be the commission could in the CCN proceeding say this is how it will be for this project in all future rate making proceedings, or it could say something different. It could say this is what we're setting in your example for depreciation rate now, and this could be evaluated in future base rate proceedings, for example. But I think the CCN statute in New Mexico establishes that discretion with the commission at the time of writing its CCN decision.
So am I understanding correctly that what you're saying is that it will be at the commission's discretion whether this could be done as part of a rider filing or done as a base rate filing in the future?
Or as part of this proceeding, yes.
A part of this proceeding, got it. Given the requirement of the Energy Transition Act for a transition to cleaner energy resources, will SPS be adding additional renewable generating resources to its portfolio over the next 20 years?
Yes, I would expect that we will.
Does SPS plan to recover the cost of all of these additional resources through a rider?
At this time, we think the RPS rider is an appropriate recovery mechanism for renewable energy projects that are used for RPS compliance. So to the extent future renewable energy resources have RECs associated with them that are retired for RPS compliance, we could seek recovery in the RPS rider. But as I discussed, Rule 572 contemplates rider recovery, deferral with a WACC return, or fuel recovery through SPS's fuel and purchase power cost adjustment clause as recovery mechanisms for renewable energy costs incurred to comply with the RPS standards.
Okay. And you discussed several of my next questions with Mr. Stoffel, so I'm going to skip those. When costs are recovered through a rider, there's generally a true-up mechanism to ensure that the company actually recovers all authorized costs. Is that correct?
That's not always true with a rider, but that is true in the RPS rider. It has a true-up both for costs and a true-up, what I refer to as for sales. So we evaluate the actual costs incurred in a program year, and we also look at recoveries through the rider by customer class.
Okay. So if these same costs were recovered in base rates, there's a possibility that in a given year, revenues may be higher than authorized or lower than authorized. Is that accurate?
Yes.
Would you agree then that shareholders have a guarantee of cost recovery when the costs are recovered through the RPS rider?
No, not entirely. Again, the commission can find that incurred costs were imprudently incurred and can still disallow them in a prudence review. That prudence review can take place in an RPS filing, or it could take place in a subsequent proceeding if the prudence review doesn't take place in the RPS rider and the costs are transitioned into base rate recovery in the future.
Okay. Aside from a finding of imprudence, are there other situations where the revenue requirement would not be recovered?
No, and again, that's consistent with Rule 572 that the utility recover all of its costs incurred for compliance.
Okay. You have already testified, and I don't want to mischaracterize your testimony, that no part of the costs that are considered uneconomic, no part of the costs associated with the projects being proposed here are considered by the company to be uneconomic. Is that, tell me if I'm mischaracterizing, that was part of your conversation with Mr. McMillan earlier?
It was, and you're correct. We do not consider them to be uneconomic as these projects were selected as part of the recommended portfolio in SPS's 2022 all source RFP. By default, that recommended portfolio is the most reliable and economic set of projects selected in that competitive solicitation process.
All right. And I want to just confirm that SPS has never asked for these kind of generation resources to be the cost to be recovered through the RPS rider. Is that correct? This is something that the company is doing for the first time in this case.
Yes, it is correct. This is the first time we've requested this recovery mechanism for company-owned renewables. There's been many references to the Hill and Sagamore wind facilities, which the company does own. But as parties are familiar with in this proceeding, there's a very unique and detailed settlement agreement regarding the cost recovery for those projects.
Got it. Are you aware of any other New Mexico utility who has requested recovery through the RPS rider for these kinds of projects?
Yes, I believe PNM, Public Service Company of New Mexico, has proposed or had proposed and recovered a solar facility through their RPS rider.
A solar facility that was not being proposed specifically for RPS purposes? Like, is it a comparable situation to what you're proposing now?
I don't recall that PNM filed a CCN for the project. I believe they presented the project in their RPS plan and report for that was the first time they presented the project. That's my understanding.
Okay. Do you happen to remember what case that was?
I don't remember the case number, and I'm trying to recall the name of the solar facility, and it is escaping me right now. I apologize.
Okay, I'll move on and maybe we'll remember it later. Do you agree that using the RPS rider to recover investment that is needed to meet capacity requirements would be a fundamental change to the way that RPS has been used since its inception?
No, I don't think so. And the reason I say no is because I don't think that these two things need to be mutually exclusive. We have several very good solar projects in SPS's system that are utilizing existing interconnection facilities, reducing costs and investment for customers, while at the same time funneling hundreds of millions of dollars of federal tax incentives to New Mexico retail customers. And it is absolutely, the capacity from these projects are absolutely working to satisfy SPS's near-term and long-term capacity needs. It just so happens that these are also renewable resources that have RECs attributable with them that can be retired for RPS compliance. But I think the fact that these solar projects do all of those things is not a problem. And the fact that they are also and primarily capacity resources selected in response to our competitive solicitation should not overly influence the Commission's determination for New Mexico specific cost recovery in this proceeding or in a future one. The RPS rule clearly identifies self-builds as eligible for RPS compliance. And also the RPS statute establishes again that all costs incurred for RPS compliance should be recovered. The RPS rule then outlines 3 mechanisms for cost recovery, including the RPS rider, deferral with a WAC return, and recovery through the fuel clause. So all of those things line up and support SPS's proposal to not only get a CCN approval for these projects to satisfy our capacity need, but also to recover the revenue requirement through the RPS rider if we're retiring RECs from these facilities for compliance in future years.
Okay. Would you agree, however, that using the RPS rider to recover investments that is needed to meet capacity requirements is a fundamental change to the way that capacity costs are recovered in New Mexico? So sort of flip the question around.
Technically, but that's just a function of SPS not owning renewables.
Could you explain?
So you're saying most of our capacity costs are not recovered through the RPS rider, and I'm saying these capacity projects that are proposed here, the SPS solar projects, are company-owned renewables. So they're not quite equivalent to non-renewable or thermal resources or other capacity resources on SPS's system.
I'm sorry, are you saying that SPS doesn't have any renewable resources on its generation system as of right now?
I'm saying our company-owned resources are not recovered through the RPS rider, but for these solar projects as we've proposed.
Company-owned, okay. Go ahead and flip to page 45 of your rebuttal testimony, please.
Okay.
I just want to confirm that you did state in your testimony that the company is not opposed to transferring these costs to base rates with each new base rate case, which was a proposal that was proposed by Ms. Crane.
That's right. This morning I testified that I think there's benefits to it staying in the rider, primarily through the true-up mechanism of the RPS rider. But if the commission would prefer that the cost recovery be transferred into base rates in the first case following COD, and that it no longer be recovered in the RPS rider. SPS is not opposed to that determination.
And is it accurate that the company has been filing a base rate case like approximately every 2 years in New Mexico?
Approximately. We've had several wholesale ramp downs driving the timing of our base rate case filings, as well as the Hale and Sagamore facilities pursuant to that wind settlement.
All right. Moving on, I just have one subject left. I'd like to talk a little bit about the off-system sales for the battery storage system.
Okay.
And I just want to confirm SPS doesn't retain any margin from sales made from the energy generated at Sagamore and Hale.
We did for a portion of time under the stipulation, but we do not today.
And you stated in your testimony today and your pre-filed testimony that the shareholders should retain 10% of the BESS margins due to the unique nature of the BESS project.
Yes.
So earlier this morning, you were discussing with Mr. McMillan, and again, correct me if I'm mischaracterizing your testimony, that the 10% retainment is justified in part because essentially there are decisions that are going to be made on the ground about this facility, when to charge, when to discharge, cost, timing, things like that. Is that relatively accurate?
Yes, that's accurate. It's also the off-system margin sharing percentage that was in place and authorized by the commission prior to the agreement in 17-00044.
I'm sorry, could you say that again?
The 90-10 off-system sales margin sharing percentages were also the commission authorized split before the agreement in case number 17-00044.
Okay. And you just said that there was a time limit on that 90-10 split and that it's no longer in place now. Is that correct?
It's no longer in place for Hale and Sagamore.
Yeah, right. No longer in place for Hale and Sagamore. Okay. If you look at page 55 of your rebuttal, you're discussing these off-system sales, the 90-10 split. And you use the phrase additional expense risks on line 2. Are the additional expense risks that you're, well, let me back up. You use the phrase additional expense risks in your pre-filed testimony, but am I correct that you don't explain or quantify what these additional expense risks are?
I don't believe that I have outlined that.
Okay. And are these additional expense risks the same sort of things you were discussing with Mr. McMillan this morning, or does this phrase additional expense risks refer to something different?
I think our discussion this morning covered what I was intending by this language in my rebuttal testimony.
So then, it's your testimony that the expense risks that you've discussed are the situations in which there are going to have to be these sort of on-the-ground decisions made about the BESS project. That's what you were talking about when you used the term additional expense risks?
Yes.
I think I'm just a little bit confused about how does that equate to a risk, since that is a process that has been contemplated and will in fact be taking place. How does that align with the idea of compensating shareholders because of an additional risk, if this is something that the company knows and expects is going to be happening on a regular basis?
I understand your question. The context of charging and discharging this battery is relatively subjective, right? We'll be faced with market energy prices at a certain point in time, and we'll need to make an operational decision as to whether that is the right time to charge the battery or not. And it's hard to know if that is going to be the most optimized time for battery charge. We certainly want to charge the battery in periods of low cost energy and discharge the battery in periods of high cost energy, especially if the battery is being used for an off-system sale. That's the basis of the energy arbitrage. So there is risk to the company from a regulatory commission reviewing that dynamic, the value of that energy arbitrage, and determining whether or not the value was enough. There's risk to the company in a regulatory commission saying, we think you should have operated your battery differently. And that is in addition to the operational risks by managing an asset in this manner. There are expense risks associated with whether or not that optimization is found to have been the best optimization. And I think that's a relatively new dynamic with respect to battery energy storage systems, particularly for a utility like SPS who does not have batteries currently installed on the system and operates in the Southwest Power Pool, where there is a robust market dispatch in the region.
Okay. This BESS system is a relatively new technology for SPS. That's what you're saying as part of what you were just saying? It's a relatively new technology.
It is.
Okay. So I have two questions. This kind of decision making that we're talking about right now, are those kinds of decisions only made in the context of this battery storage system?
In those specifics, yes, because we don't charge other generating resources.
Okay, but decisions are made based on timing and pricing in other areas of the company as well, right? It's not just in charging or discharging this new technology. I mean, it's my understanding that analysts sort of make these kinds of decisions in a lot of different contexts for electric utilities. Is that correct?
Perhaps maybe a close analogy would be fuel supply procurement for a natural gas generator. That might be the closest analogy I can come up with to, determining when to charge a battery, kind of a similar output of when to buy natural gas and at what price.
I think that's what I was thinking. Yeah.
That kind of dynamic is also subject to commission review, right? So we expect that same kind of dynamic with regard to the energy arbitrage valuation of battery operations.
Okay. Does the company provide its shareholders with any sort of additional expense risk compensation in that situation?
New Mexico
similar
used
to this?
Off-system sales margin sharing in New Mexico started with the name experimental sales, I believe. And I believe for SPS, when off-system sales margin sharing was first implemented, the company retention was 25%. So
Okay.
again, prior to that 2017 CCN agreement for assets at the time, SPS has consistently had an off-system sales margin sharing framework in New Mexico.
But that off-system sharing framework doesn't exist anymore. Is that what you're saying?
For existing assets, the agreement in the wind CCN was that SPS would no longer retain a portion of off-system sales margin for the generation fleet at that time. It is SPS's position that that stipulation did not require 100% off-system sales margins to customers for all new generating resources in the future.
Okay. So part of the reason in that situation and in this situation, am I correct? It's the newness, it's the novelty of what SPS is proposing as part of the justification for that retention.
Somewhat. The battery is a new technology, but this is also the first generator that SPS has proposed since the wind settlements. We have not brought on other new generating assets since Hale and Sagamore. We've converted a generation unit from coal to natural gas, and the commission has reviewed that application in a CCN proceeding. But this is the first, this application is the first CCN proposal for new generation on SPS's system that would not apply under the, call it 100-0 off-system sales margin sharing provision of the stipulation in 17-00044.
Okay. And is SPS proposing any kind of a an end date or like a sunset clause to this 90-10 split, or is the expectation that this 90-10 split is going to exist for the entirety of the life of the battery storage system?
The latter. SPS's position is that it's reasonable for an off-system sales margin sharing percentage to be reestablished for all of SPS's incremental generating resources going forward. Our proposal in this case relates, of course, only to the battery. We did not propose that for the solar, but again, from a policy position, it's not unreasonable to reestablish that off-system sales margin sharing for SPS's generation assets beyond what was included in rate base at the time of the 2017 rate case.
Why was this 90-10 split proposed for the battery storage system, but not under that analysis, but not the solar facilities?
I think the operational characteristics of the battery most demonstrate the applicability of off-system sales margin sharing opportunities and support that policy determination from the commission based on the energy arbitrage opportunities of a battery energy storage technology, which is not present with the solar facility.
You envision that additional battery storage projects will be undertaken by SPS in the future?
Yes,
okay.
We've identified a large dispatchable need in our current IRP.
Right. Is it the company's position that shareholders should retain 10% of off-system sales on all of these future BESS projects?
We haven't made that proposal in this proceeding, but that would not be, from my perspective, an unreasonable proposal in future CCNs. Of course, we haven't gotten to that point yet. We haven't even issued the RFP for the IRP yet.
Okay. Okay, I've just got a few more questions. If you could go to page 53 of your rebuttal testimony, please. Almost done.
Okay.
You're so fast. On page 53, you imply that the company needs the 10% incentive to effectively manage off-system sale from battery projects. And then on page 33, I don't want to just read your testimony, but is that an accurate reflection of page 53?
Well, you said I was fast, and now I'm not seeing where you're reading from.
There's an implication that the company needs a 10% incentive to effectively manage off-system sales from battery projects. So essentially, I'm just restating what we already said earlier, which is on-the-ground decisions are going to need to be made in order to effectively manage this, part of the justification for the 10% incentive.
Sorry, the Q&A here, at least the one that starts on line 8, is referring to the battery's ability to make off-system sales as an impact to customer reliability. So your page reference is a little bit of a stretch.
Yeah, probably. I can accept that. Do you want to go to page 33?
On
Sorry, I
rebuttal?
realized- a rebuttal, please, yes.
Okay, I'm there.
I'm now realizing that several of these questions were already answered, so I'm not going to restate them. So I'm just going to ask, and this is unrelated to page 33, so please disregard that. Generally speaking, is the company guaranteeing that the projects included in the application would be completed for the cost of 768.4 million that we discussed earlier? That was in the table BAT5.
Yes, that is the commitment that SPS is making with regard to Rule 580 and the certificated cost estimate requirement of the commission.
Okay. So as a whole, ratepayers would be at risk for increased capital costs for the cost of monetizing tax credits, for carrying charges on unused tax credits, and they're going to be giving up 10% of certain off-system sales margins under the company's proposal. Is that an accurate reflection?
No, I disagree that there's new or additional costs on the DTA carrying costs. Customers pay a WAC return on the Hale and Sagamore DTA in base rates today. So it's a very similar treatment that we've proposed here. I think your first item, I think that was the second item. I think your first item was related to the transaction costs for transferability. And again, while there is a transaction cost that would be incurred, the benefit is reducing the accrued balance of the DTA over time. So I think as we looked at one of the discovery responses this morning, either with you or previously before lunch, that the transferability cost is a one-time cost that's going to be offsetting a multi-year potentially carrying costs on a DTA balance. So I disagree with your characterization of those three items with that respect. I do agree with your characterization of the off-system sales margin sharing, but again, that is a framework that currently, or I'm sorry, previously existed in New Mexico for SPS's entire generation fleet.
It doesn't exist anymore.
For the existing generation fleet.
Okay. I have no further questions. Thank you very much for your time.
Thank you.
Okay, next request for cross-examination is by CCAE, and of course, for the record, CCAE is present with Ms. Lynch representing. Ms. Lynch, you requested 60 minutes, so begin your cross-examination, please.
Thank you, hearing examiner, and it's nice to see you, Ms. Trammell. I've tried to group some of the questions by topic, and I hope they come out that way. So to begin with, in your opinion, is consideration of available tax credits to SPS reasonable?
It's nice to see you as well, Ms. Lynch, but I don't understand your question.
Oh, you don't? Oh, geez, we have
In the
such a hard
context,
time understanding each other. Let me
I'm
see
sorry,
here. Is consideration for by SPS of tax credits it will receive reasonable? Is that a reasonable consideration to you know, possibly think about the role that tax credits would play in any proposal that SPS makes for the commission, before the commission?
yes, I think tax credits are a reasonable basis in a number of contexts, just in the frame of this proceeding. They're reasonable to consider for the evaluation of projects bid into the competitive solicitation as they reduce the overall cost of projects for customers. They're reasonable to evaluate in this CCN proceeding because our proposal is to flow the value of those tax credits back to customers in a timely fashion upon commencement of cost recovery. It's also reasonable to consider, again, in this CCN proceeding, the changed tax credit parameters and frameworks around transferability, which are present today for utilities through the passage of the Inflation Reduction Act and were previously unavailable or was not a framework a federal tax law in the United States, but they are now and will apply to production of these facilities. Those are just a couple examples of why SPS believes it's very reasonable to evaluate federal tax credits in the context of this competitive solicitation as well as this CCN.
Okay. And I'm not a tax expert. You probably know more about tax credits than I do, but they have play an important role in this proceeding. Do you know whether SPS will allow any of the tax credits available to it to expire or to not be used?
I don't know, again, if we have that ability or not.
Okay. Please turn to your direct testimony. And we'll be looking at page 5.
Okay.
Let me see, I'm navigating there. Which is actually PDF page 11. So at page 5, you refer to material customer growth, economic development, and resource adequacy through the SPP pool and the industry, and the aging generation units have created the capacity need for this portfolio, correct?
Yes, that's correct.
When did SPS first become aware of the changing capacity need?
I think SPS has been aware of its changing capacity need for many years. We have the expected retirement dates of all of our generating resources. We have the planned expirations of our PPA contracts. What was relatively new was the change in the planning reserve margin requirement by the SPP, which was increased in 2022, I believe effective as early as summer of 2023. But generally, SPS has been aware of where its generation capacity needs will be in the future, again, largely based on the age of its existing system and the timing of the expiration of current PPAs.
Okay. And in this proposal, what facilities will have their lives extended?
The recommended portfolio that SPS selected as a result of the 2022 all source solicitation includes the unit life extensions for Cunningham 2 to align the retirement of the existing gas generation with the in-servicing of the proposed solar generation at that point of interconnection. And also the recommended portfolio includes the extension of Maddox Unit 2 as part of, again, that recommended portfolio, instead of replacing Maddox 2 with other new generation selected in the portfolio, or I'm sorry, selected in the solicitation.
Okay. And in your direct testimony, you define 2 types of capacity. You define, or you use the word capacity and dispatchable capacity. Can you discuss how those 2 are different or the same?
Sure. At a high level, for example, both a solar resource and a battery energy storage resource has accredited capacity. In other words, we can count on capacity from those resources to offset our accredited needs as we're comparing that to our load obligations for determinations of our resource adequacy requirements in the Southwest Power Pool. But a solar facility is an intermittent technology. It is not dispatchable. So while they both have capacity value, the solar is not dispatchable, whereas the battery is dispatchable capacity.
So is it fair to say that a dispatchable facility, is that the right word?
Facility
Would you
or
refer
capacity?
is the best um storage project a facility?
We can call it a facility.
Okay, I don't know if there's a better term for it,
Pro-
but
Project.
okay, project. Are dispatchable projects ones that can be called upon at any time to dispatch energy?
Generally, yes. There are some dispatchable conditions or dispatch conditions under the PPA for some batteries. So for SPS's battery, this would not apply, but in some context, you may have dispatch limits under a PPA agreement with a third party. But yes, we can call on that capacity to be dispatched when we need it or when it is dispatched in the Southwest Power Pool.
Okay, great. I think this, if we could turn to page 8 of your direct testimony, lines 6 through 10.
Okay.
Another or one of the reasons for extending the life of Cunningham is to provide needed capacity before the solar project is placed in service, correct?
Correct. Its current retirement date is 2025. The solar as proposed in the CCN is expected to be online in 2027. So we find it very reasonable to extend the existing gas generation's life for that approximately 2 years to avoid creating a 196 megawatt capacity gap on the system in that time frame.
The other reason proposed for the extension is to provide for additional dispatchable capacity. Is that correct?
Yes.
Okay. Do you know what percent of the capacity will be for capacity reasons only versus the percent that is needed for dispatchable capacity?
In this sentence of my testimony, which starts, it's the latter part of that sentence, it starts on line 9, referring to the second. So that's referring to the second of 2 service lives we're extending as part of the recommended portfolio. Recall that the all source RFP was issued potentially searching for replacement capacity for 5 generation units, Plant X1, Plant X2, Cunningham 1, Cunningham 2, and potentially Maddox 2. So as a result of the project selection, the bid evaluation and project selection in that competitive solicitation, we chose not to replace Maddox 2 out of this solicitation, but rather to extend its life from, again, the currently approved 2025 through 2028. So extending the existing gas life provides that additional dispatchable capacity that our system needs through 2028 under that proposal. And the reference to dispatchable capacity is again a reflection of the need that was identified in the all source solicitation, which is being satisfied here through SPS's election not to replace Maddox 2 at this time, but rather extend the unit.
So that what is the percent of that dispatchable need? Is there any way to quantify it?
Mr. Elsey probably could. I recall the megawatts of Maddox 2, but I don't know the total of his analysis of dispatchable capacity from now to 2028. I can offer you, Ms. Lynch, that we have roughly 4,300 megawatts of dispatchable capacity on our system today, installed nameplate capacity. Sorry, I said dispatchable, I mean nameplate. I think Maddox 2 is roughly 62 megawatts.
Okay. Do you know whether capacity and dispatchable capacity were at issue in the 22-00286 rate case that you filed?
I don't recall a particular party bringing that up. We certainly had unit life extensions that were subject to that proceeding. So we talked a lot about available capacity on SPS's system. I don't remember a party specifically raising issues about levels of dispatchable capacity in that case.
Do you know whether the I think it's the SPP pool was at issue there?
We certainly discussed the planning reserve margin requirement increase that was implemented in 2023, primarily in the context of SPS's request to extend the lives of its Nichols units 1 and 2 in that rate case, which was approved.
Is the planning reserve margin different from the needed dispatchable capacity?
Mr. Elsey would probably be the better witness to address those questions.
Okay. Let's see. All right, so we'll turn to page 10 of your testimony, lines 2 through 5.
Okay.
And we'll start at the portion of your testimony. For an average residential customer, the average annual impact of the SPS self-build projects is estimated to be $1.53 per month. However, due to the timing of federal tax credits, limited rate impacts will be experienced by customers before 2036. And my question is, what are the limited rate impacts?
This statement is a reflection of the 10-year window for production tax credits under the IRS regulations and SPS's proposed 5-year amortization of the battery ITC. Those significant tax credits, which are estimated to be close to $500 million for the SPS self-build projects, significantly counteract the rate impacts, especially for the first 10 years of operation of the facilities. So this sentence is characterizing that we have calculated an estimated rate impact for an average residential customer, but in reality, the offset through fuel of the PTC credits to customers will, similar to our Steel for Fuel initiative, where the avoided cost savings and prevalence of federal PTCs offset the invested capital, we see a similar relationship with these self-build solar projects and the self-build battery project.
So is the $1.53 a reflection of including the tax credits, or would the $1.53 go down after the tax credits are applied? Meaning, will they decrease? Will that amount decrease? Do you know?
It will decrease.
Okay, and do you know by, do you have an estimate by how much?
I do not.
Okay. So now we'll turn to pages 14 and 15 of your direct testimony.
Okay.
And the question I have is regarding these dispatchable PPAs, are the renewable CCNs that you propose in this application contingent upon the PPAs in any way?
I wouldn't say contingent. SPS has requested commission approval of its entire recommended portfolio. The entire recommended portfolio is needed to address our resource need and capacity need through 2027. So the whole package we're requesting the commission approve, but approval of the projects are not contingent upon each other technically. Would just reiterate they are all needed.
Mhm. Okay, good to know. Let's see. And this just gets to a general question of, what SPS might consider as an economic option. Could you break that down? What typically SPS is looking at when it wants to determine whether a proposal or a project is economic?
Generally, economic evaluation of resource proposals occurs through our bid evaluation process. Mr. Elsey testifies to that extensively and can share more detail on the findings and the economics of the recommended portfolio in this proceeding, as well as other bids that were received in response to our RFP.
Okay. Do you know whether the extension of the life of Cunningham will require the use, like more use of water at the facility?
No, it will not.
And why not?
I mean, compared to its operations today, there'll be no change. We're just continuing the operations of the facility.
Does the facility currently use any water today?
It does, but we won't be increasing usage out of that water, generally speaking. Obviously, water consumption's dependent on generation output, but again, the facility utilizes water today, so I don't see that as an incremental change in water usage through the extension. Will we be using water for 2 more years? Yes, but not significantly different from the water consumption at the facility today.
Okay. And okay, that's good to know. Do you know where what the source is of that water?
It's my understanding that the units at the Cunningham complex are cooled through groundwater, but Mr. Elsey may be able to confirm that actually, or Mr. Lytle may be the better witness.
Okay. And do you know if that water is reused at all?
I believe it is, but Mr. Lytle can confirm.
Okay, great. I think within this context of the PPAs, I'm sorry, I can't pull you to your direct testimony, but you use the term finalized, that the PPAs will need to be finalized. What does that mean, that they'll need to be finalized?
Sure. When the PPAs are selected as part of the resource package in a competitive solicitation like the one SPS conducted in the fall of 22, a subsequent process occurs with developers to negotiate the final PPA. So there may be terms included by the developer in the bid submittal, but those terms will need to be negotiated and finalized and then memorialized in a purchase power agreement executed by both counterparties subsequent to the project award and during those negotiations. So that is what I'm referring to, at least in this section of my testimony, page 15, line 2, where I say once the PPAs have been finalized, so the negotiations have completed and the purchase power agreements have been executed by both counterparties.
Okay. Are those PPAs, do the terms usually include agreement to use a certain source for a duration of time? Meaning, would SPS be required to use energy generated at a source for a certain amount of time because it has signed a PPA?
The specifics would definitely depend on the contract executed, but generally there are energy provisions in a PPA, yes. And similarly, like for the battery PPA, which is not subject to this proceeding, but relevant to the context of this recommended portfolio, it's more of a capacity payment structure as discussed by Mr. Bornhofen.
Okay. I'm just I guess I asked that question partly because I'm wondering if the solar project at Cunningham could be brought online, meaning construction happens, everything falls into place, and it can be brought online before 2027. Would that be a possibility?
It's not a possibility. That's actually something that we looked into and was determined to not be feasible, primarily given the materials procurement that we had, and that would intensify the needs for in-servicing projects in 2026.
Okay. Is there a chance that the solar project may not come online by 2027?
Cunningham 2,
Yeah.
as they stand here today, I think there's always a chance, but we feel very confident in our construction timelines.
Okay, so could you give a, like, in your best guess, would you say that's a 90% surety or?
I can't assign a percentage to it, but the company has, through its testimony in this case, committed not only to the cost estimates for the portfolio of self-build projects in this case, but also our ISDs. So we've committed to the commission in the context of the 580 requirements that we will construct the projects within those cost estimates for the portfolio of self-build projects, as well as complete Plant X and Cunningham 1 solar installations by April of 26 and Cunningham 2 solar installation by April of 27.
Okay, great. This next question is going to go back to where we started. It deals with the tax credits. And I'm just wondering if it's a requirement that SPS sells any tax credits to entities engaged in clean energy?
It is not a requirement to my knowledge. The IRS regulations dictate that the entity the unused tax credits are transferred to must be unaffiliated with, in this case, SPS, an unaffiliated third party, but I'm not aware of any other restrictions or qualifications for the entity that might be interested in buying unused tax credits from SPS.
Okay, so the entity receiving the tax credits, in this case SPS, receives them for pursuing or engaging in the construction and operation of clean energy, but it is not a requirement that you sell those tax credits to an entity engaged in a similar capacity. That's my understanding of what you said. Is that accurate?
Correct. There is no requirement for that.
Is it necessary for those tax credits to be resold? I don't know if resell is the best word, but for those tax credits to be sold to an entity engaged in the energy sector?
No, it can be any third party with a tax appetite.
Okay, thanks. Now we'll turn to page 53 of your direct testimony.
Okay.
And sorry, I'm still navigating. There. Oh, yeah, I'm not sure actually what this question is answered on page 53. In any case, I was just wondering, will energy at the proposed battery facility that is stored be used before energy generated by a more carbon intense facility?
That depends on the price at which the units are offered into the SPP market and how they are dispatched. SPP dispatches resources committed to serve load and for ancillary services and off-system sales through a security constrained economic dispatch. In other words, the most economic resources are dispatched first. The order in which resources fall in that stack are based on their offer prices.
Okay. And that's interesting. Do you know whether the SPP is similarly moving towards more or less renewable energy requirements?
The SPP does not set any kind of generation requirements. The SPP focuses on what was referred to as resource adequacy, so ensuring that sufficient generating capacity is available to meet peak demands, as well as also looking at what we refer to as energy adequacy for utility systems. But resource decisions and the technology that utilities add to their generation systems are matters left to the state commissions. SPP does not decide generation addition parameters.
Okay, so if I'm understanding that correctly, the commissions would approve of the company's proposal to provide any energy generated to SPP. Is that
The commission
accurate?
would approve a certificate of convenience and necessity to develop, construct, own, and operate a generator. The commission's not directly authorizing an offer price into the SPP marketplace.
Okay, and the offer price, is that something SPP sets or that SPS sets?
SPS sets, but market offer prices are reviewed by the SPP market monitor.
Okay, and the commission is not involved at all in the setting of that offering price?
No, it is not. The commission is typically engaged at SPP through the Regional State Committee, which does address resource adequacy issues and is a specific committee of the SPP, but not addressing offer prices.
Okay, got it. Ms. Trammell, that's the conclusion of my those are the conclusions of my questions for you, and I appreciate the time and the clarity that you provided here.
Thank you, Ms. Lynch.
Okay, thank you. And next for cross-exam is staff, Mr. Bogacko.
Mr. Hearing Examiner, thank you. I will try to make this quick. Ms. Trammell, good afternoon. How are you doing?
Doing great. Hello, Mr. Bogacko.
I would like to direct your attention to your direct testimony, SPS Exhibit 2, specifically there on page 97.
Okay, 1 second.
No problem.
I'm there.
You see there where you talk about, well, the question posed is, has SPS provided an affiliate agreement memorializing the relationship between Nicollet Lands and SPS? And your answer to that question is no, not at this time. And then you go on to offer that once regulatory approval of the SPS self-build solar projects is obtained, SPS and Nicollet Lands will execute a services agreement. Is that a fair summation of what you're saying there on page 97?
Yes, sir.
When the time comes and the services agreement between SPS and Nicollet Lands is executed, is SPS amenable to filing notice of that services agreement with the commission in accordance with Rule 450.11A?
Yes.
And specifically, if you haven't guessed already, I'm thinking about Ms. Labor Tessero's recommendation for just that in her testimony. Do you recollect that?
I do, and we are not opposed to that recommendation.
Thank you for closing the loop on that. Next thing is concerning transaction costs related to Class 1 transactions. Is SPS opposed to having those addressed in a future base rate case?
Generally not opposed. I'm not sure we'll have transaction costs to effectuate those agreements. Obviously, there's costs that the agreements cover. Are you referring to incurred transaction costs between the SPS and its affiliate, or the actual costs of, say, the materials and supplies that would be transferring to SPS under
SPS and its affiliate.
Okay. The only reason I hesitate is in the example of materials, say solar panels, that is subject to the affiliate agreement between SPS and Capital Services LLC. The costs of those materials, once installed, of course, would be in the revenue requirement for the projects. Should the commission authorize recovery of the self-build solar projects through the RPS rider, then the first time that those costs would be reviewed by the commission, maybe in an RPS case, Mr. Brigacco, rather than a rate case.
All right, and you raise an interesting point. As we sit here today, what do you think is going to come sooner? SPS's next rate-based case or SPS's next RPS case?
Honestly, I think it depends on the outcome of this proceeding. If SPS's requests to recover these projects through the RPS rider are approved, it may delay the filing of an SPS base rate case. There are also other decisions pending before the commission still that may dictate the timing of SPS's next rate case. So I can't say that with utmost certainty, but generally these generation projects are a material driver of SPS's deficiency in the coming years.
Well, dovetailing off that, I would like to now direct your attention to your rebuttal testimony, SPS Exhibit 3.
Okay.
Specifically, I'm interested in page 50.
I'm there.
And do you recall Ms. Labor Tessero's concerns regarding SPS's notion of putting the solar projects into the RPS rider against the backdrop of having or not having an approved REA plan?
I do.
And I would direct your attention then down there on lines 5 through 9 of page 50, where you say in apparent response to that concern, and I'll quote, "Accordingly, staff's concerned that the costs of the solar projects are not consistent with any commission-approved REA plan should not prevent SPS from seeking pre-approval of SPS's proposal to request inclusion of the SPS solar project costs in SPS's RPS rider in a future proceeding." Did I butcher that, or was I accurate in reading back your testimony?
Spot on, sir. So
down there on lines 7 through 9, we start with the word pre-approval. I mean, when I read this, it sounds to me like you're saying what you want in this case is approval of SPS proposing in a future RPS case to recover the cost of the SPS solar project costs in an RPS rider in that proceeding. Am I mistaken?
What we're trying to avoid is going to an RPS proceeding and the commission telling SPS that your request cannot be handled here in this proceeding. I think pre-approving the reasonableness of recovering self-billed costs for compliance with RPS requirements is in the public interest, as it provides regulatory certainty to SPS as well as all of the interested parties. It's not pre-approval to say that, for example, there would be no interventions in that case, or parties could, would be prohibited from taking positions in that case. It's just a recognition that Rule 572 outlines, again, those three methods of cost recovery, and we intend, to the extent that these projects are used for RPS compliance, to seek recovery through the rider.
But this isn't an RPS case, is it?
No, sir.
And are you asking for a pre-approval of the propriety or reasonableness of those solar project costs in this case against the backdrop of the RPS?
No, sir. I'm not requesting that, we are not requesting that the commission pre-approve any prudency of these facilities before they've even incurred any costs of construction or been placed in service.
So when I go back and look at, for example, what you say on line 9 there of your rebuttal on page 50, you talk about a future proceeding. So I'm still a little confused. Does that mean then that the next thing we'll see from SPS in accordance with what we see here will be an RPS filing to try to get these costs into the RPS rider?
Based on the in-service dates of the projects in the CCN, we would propose in the 2025 RPS plan and report to recover the 2026 in-service projects through that 2026 RPS rider.
All right, well, thank you for that. I think I understand a little bit better. And as you probably guessed, some of the other things I wanted to talk about have been whittled down to practically nothing. So I'm going to let you off the hook for whatever that's worth. And Mr. Hearing Examiner, I pass the witness.
Well, thank you. And I apologize if my testimony in response to staff was unclear.
Okay, thank you, Mr. Bagacco. Let me see. It's 2:45. Ms. Hardy, I'm going to assume you have redirect. Is that correct?
I do, Mr. Examiner.
How approximately how long do you think it'll take for redirect?
I don't think it will take too long, probably 15 minutes.
Okay. Madam Court Reporter, are you good going until 3 o'clock before we take a break? Okay. All right, Ms. Hardy, redirect, please.
Thank you, Mr. Examiner. Ms. Trammell, Mr. McMillan asked you several questions about the Commission's order in case number 12-00350 UT, which authorized SPS to recover the incremental cost of RPS compliance through the RPS rider. Do you recall those questions?
I do.
To be clear, has SPS ever previously requested recovery of other non-incremental costs through the RPS rider?
No, we have not. This is the first case in which SPS has made a related proposal.
Are you aware of any authority stating that RPS riders can only be used to recover incremental costs?
No, I am not.
And Ms. Trammell, Mr. McMillan asked you a number of questions about the Commission's order in case number 20-00158 UT that was issued on December 7th, 2022, which is OPL Exhibit 5. Do you recall those questions?
I do.
And specifically, Mr. McMillan talked with you about the RPS rider discussion in paragraphs 159 to 173 on pages 74 through 84. Do you recall those questions?
I do.
Did SPS file a motion for rehearing in case number 20-00158 UT?
Yes, we did.
And did the commission grant in part that request?
It did, and I think in the commission's order on rehearing, it may have removed several of the paragraphs that Mr. McMillan and I were discussing from this December 7th order earlier today.
And Mr. Examiner, I'd like to share my screen, if I may.
Okay, give me 1 second. Okay, you are now co-host. You should have the ability to screen share.
Okay. Thank you. Can you see my screen?
Not yet.
Oh, wait. Let's see here.
There we go.
Okay. And is this the commission's order in case number 20-00158 UT granting in part SPS's motion for rehearing?
Yes, it appears to be.
And I'm going to show you ordering paragraph D of that order. And can you please read the first sentence?
Pursuant to section 62-1016, section D3 of the final order issued in this docket located at pages 74 to 84 is vacated.
And are those the pages of the order that Mr. McMillan was talking with you about earlier?
They were.
Stop sharing here. Mr. Stoffel asked you a number of questions about whether SPS could record the balance of the ITC associated with the battery as a reduction to the capital cost of the battery. Do you recall those questions?
I do.
Can you please clarify how SPS proposes to treat the unamortized balance of the ITC?
Yes. The amortization of the ITC generally is recorded as a deferred tax liability. Deferred tax liabilities have the effect of reducing rate base. That is quite different than the proposal that I understood Mr. Stoffel was describing, which is reducing the capital costs of the project by the investment tax credit that SPS would receive for the battery project. Yes, I agree with Mr. Stoffel that reducing the invested capital also reduces a level of rate base, but with that comes for a rate regulated utility like SPS, the need to record a capital impairment. In other words, SPS would have to record the difference in the invested capital total and the lower invested capital amount offset by the battery ITC as a disallowance. So I don't think that Mr. Stoffel was implying that SPS should take a 30% or 40% capital impairment on invested capital. And that's why I disagreed with his presentation of that option as a reasonable option for the commission to decide in this proceeding. In my mind, equivalent methodology is as SPS has proposed to record that deferred tax liability, capturing the ITC for the battery project, which again, functionally is a reduction to rate base, but avoids the very damaging accounting recognition of a capital impairment for a rate regulated utility.
Mr. Stoffel also asked you questions about SPS's request to earn a WACC return on the DTA. Do you recall those questions?
I do.
If SPS did not earn a WACC return on the DTA, how would that impact treatment of the customer benefits that result from the PTCs and ITCs?
Again, the presence of the need to earn a return on that DTA balance is a reflection of SPS crediting to customers the PTCs and in this case ITC benefits to customers in a very timely fashion. So it's SPS's position that no return on the DTA would the functional equivalent of that would be also not returning to customers or not flowing through to customers the grossed up value of the production tax credits as generated and the ITC to customers. Again, that is not SPS's proposal. Our proposal is to deliver the cost savings from these projects in a timely manner through fuel. And accordingly, if there is an unused tax credit that SPS is unable to transfer, to appropriately record that into the DTA balance and earn a return. That concept balances all of those needs while still prioritizing the timely receipt of customer benefits to SPS's New Mexico retail customers.
Ms. Barrett asked you questions about SPS's inability to use PTCs generated by the Hale and Sagamore wind projects. Do you recall those questions?
I do.
Do customers receive the benefit of the PTCs generated by Hale and Sagamore?
Oh, absolutely. Both the PTCs are flowed through on a monthly basis through our fuel factor as an offset to eligible fuel expense. And the wind facilities themselves also create hundreds of millions of dollars a year in avoided energy costs.
Thank you, Ms. Tremmel. Those are all of my questions.
Okay, thank you. At the conclusion of redirect, witnesses excused.
Thank you, Your Honor.
Yes, I have 2:53. We're going to take a short break here and allow SPS to rotate out its witnesses. I have confidence that we'll be able to get through witness Elsie. I have 2 hours requested for cross-exam, but that might take us right up to 5 o'clock. So to the extent that we will not get to SPS's 2 other witnesses today, we'll continue with them first thing tomorrow morning. I don't think that has a conflict for anybody. I'll check the I'll check the memorandums. But I think we should be all right. That being said, let's take a 10-minute break, and we'll come back at 3:05.
Hey, Landon, just doing a quick mic check. Can you hear me?
We can all hear you.
Okay, I have 3:05 on my phone. Let's get everyone back. Madam Court Reporter, are you all set? All right, let's go back on the record. SPS, go ahead and call your next witness.
Mr. Examiner, SPS's next witness is Mr. Ben Elsey, and Mr. Lill is going to present Mr. Elsey's testimony.
Thank
Mr.
you.
Elsey, Mr. Elsey, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Elsey, will you state your name for the record?
Yes, it's Ben Elsey.
And in front of you should be what's marked SPS Exhibits 4 and 5, which are copies of your direct and rebuttal testimonies. Are the answers in Exhibits 4 and 5 the same as if you were testifying today?
Yes, they are.
At this point, I tender the witness for cross-examination.
Okay, first request is by OPL.
Good afternoon, Mr. Elsey. How are you today?
I'm well. How are you?
I'm doing pretty well. So I want to talk to you about the amount of dispatchable capacity on SPS's system. Would you agree with me that it is important for SPS to maintain a sufficient level of dispatchable capacity to meet customer demand across hours when intermittent resource output is low?
Yes, I would.
Okay, so on page 14 of your rebuttal testimony, you state that SPS has already extensively addressed its prospective need for dispatchable generation in its IRP filing, correct?
Yes, I do.
And on that page, you state that if SPS's entire recommended portfolio is approved, SPS will have enough dispatchable capacity to meet its needs through 2027, correct?
Yes, that's correct.
Okay, I want to take a look at the IRP filing that you reference and cite on page 14 of your rebuttal testimony. Could you pull up OPL Exhibit 7?
Just going to make some room for this exhibit. Okay, and what page?
So we're going to be looking at page 4 of the filing. It's page 22 of the PDF. but it would be the internal pagination is page 4.
Okay, I'm there.
Okay, so before we get into the specifics, do you agree that OPL Exhibit 7 is a copy of SPS's 2023 IRP filing from case number 23-00073-UT from October 13th of 2023?
Without reviewing the 1,000+ pages, it does appear to be.
And, you know, are you satisfied that that exhibit appears to be a true and correct copy of that filing?
Again, without reviewing the entire document, it would appear to be.
Your Honor, I offer OPL Exhibit 7.
Request is for OPL Exhibit 7 to be admitted onto the record. Any objection?
Objections, Your Honor.
It is admitted.
Okay. So, Mr. Elsey, you already turned to page 4 of the internal pagination of that filing, right?
I did, yes.
So, on that page, SPS discusses the potential dispatchable capacity additions that it might need through the year 2030, correct?
Yes, that's correct.
Okay, so SPS states that based on generic pricing, SPS has the potential to need the following resources through 2030. And then when specifying dispatchable resources, it says a range of 1,043 megawatts to 4,290 megawatts from dispatchable resources. Is that correct?
That is correct, yes.
Okay, so that means that at some point in the next 6 years, SPS needs to acquire a minimum of 1,043 megawatts of dispatchable capacity compared to the state that it was in when this IRP filing was made, right?
That's correct. That's largely driven by the retirement of the 2 toke units, which are over 1,000 megawatts of dispatchable capacity.
Okay, and it's also the case that SPS thinks it might need over 4 times that amount, as much as 4,290 megawatts of dispatchable capacity.
That's correct. The higher end of the range is based on a higher load forecast and also assuming no new gas generation.
Okay, so if you look on the next page, SPS also gives a projected range of dispatchable resources that would be required by 2043, right?
Yes, I have it at the end of page 4 going into page 5.
Okay, and the range for 2043 is from a minimum of 4,470 megawatts up to 11,200 megawatts, right?
Yes, that's correct.
Okay, so I want to talk a bit about OPL witness Jonathan Lee's testimony. You've reviewed that testimony, right?
I have, yes.
Do you agree with his analysis on page 7 of his testimony about the net change in dispatchable capacity that will result from this CCN case and the pending PPA case?
Let me just locate that. Give me 1 second, please.
Take your time.
Mr. McMillan, do you know what exhibit that was from OPO? Is that
I
one?
believe it's OPL Exhibit 1.
Okay, and then just refer me to what page?
Page 7.
Okay, and this is page 7 in the top right-hand corner. Is that the page numbers you're referring to?
Moment. Page 7 in the top right corner, yes.
Okay. I don't
So I'm
see.
referring to, by the way, to lines 1 through 8 of page 7.
And can you repeat the question, the original question?
Yes, on page 7 of Mr. Lee's direct testimony, he addresses the change in dispatchable capacity on SPS's system that will result from this case and the pending PPA case, right?
Correct, yes.
Okay, and having reviewed lines 1 through 8 of page 7 of his testimony, do you disagree with his math there of what the change in dispatchable capacity will be on net?
This doesn't include all the numbers I would expect to see to do the comparison. So there's a couple of things I would point out. In table 5, Borger facility is described as 77 megawatts of dispatchable capacity in 2027. I'm not quite sure what that's referring to. Also in this table 5, it does not describe the impacts of Cudnam 2 or Maddox 2, though they seem to be stated below.
Okay, so in table 5, the top line on the Borger facility, so it says in here 77 megawatts. Is there a different number that you would have expected there?
Yes, I'm not sure what 77 megawatts is referring to. Essentially, the Borger facility is the existing PPA is expiring, and we're entering into a new PPA with Borger. So I wouldn't expect to see any net change related from Borger at all.
Oh, I see your point. We can clear that up with Mr. Lee. But so speaking about the math, though, so assuming that Mr. Lee added the 77 megawatts in error, and I'm not saying he did that, that would have a tendency to increase the amount of dispatchable capacity on the system, right? As opposed to putting 0 because it's no net change.
Yes, and I would expect this number to be not 77 megawatts. I'd expect this number to be between 220 or 230 megawatts.
Gotcha. But once again, the Borger facility is just, you're redoing that PPA, so there's no net change there, right?
Exactly. There would be no reduction in dispatchable capacity.
Okay, so would you agree with me that in light of the Borger facility number there, that would only tend to increase the amount of dispatchable capacity? Would you agree that after the CCN and PPA changes are made in the SPS's recommended portfolio, that would increase dispatchable capacity on SPS's system by only 71 megawatts by 2027? Or a minimum of, or excuse me, maximum of?
No, again, I think as we look at these numbers, I see several issues. These numbers, Cudnam 1 battery, for example, is listed as 24 megawatts. 24 megawatts for the Cudnam 1 battery is the accredited capacity of the battery, not the nameplate dispatchable capability of the battery. That's actually should be 36 megawatts. Wildcat Ranch in 2027, again, is the accredited capacity. It should be 48 megawatts. So I see several issues with these numbers, so I can't reconcile them at this point.
Okay, so let's put this differently. Do you know what the net change in dispatchable capacity on SPS's system would be if the commission approves the entire recommended portfolio? So net change between now and the end of 2027?
We would add 84 megawatts of nameplate battery energy storage capacity, and we would renew 230 megawatts of the existing Borger PPA. In terms of the dispatchable capacity that's retiring, Plantex Unit 1 and 2, Cudnam Unit 1 would retire, and also Cudnam Unit 2 after the solar facility was in service. I would say those units have been, for the most part, for X1, X2, and Cudnam 1 enforced outage for a couple of years. So the actual operational dispatchable capacity would be much less than that.
Okay, so I want to take that one piece at a time. So you said that SPS is adding 84 megawatts of battery capacity in the entire recommended portfolio, right?
Correct.
And so that's a net increase of 84 megawatts
Correct.
of dispatch. Okay. And you said that SPS is going to renew the Borger PPA, correct?
Correct.
And as you mentioned before, since they're just renewing that PPA, that has no net change in dispatchable capacity, correct?
That's correct, yes.
Okay, so if the commission approved SPS's entire recommended portfolio, that would result in a net change, a net increase of 84 megawatts of dispatchable capacity.
And also the fact that the Borger PPA would extend for another 15 years.
But at zero net increase, correct? In
Give or take 0, yes. There's a slight up rate, but yes.
Okay, and you also mentioned that SPS is planning to retire some dispatchable capacity, correct? Do you know the total amount of that dispatchable capacity that's retiring between now and 2028?
I don't know offhand. Cunningham 2 is approximately 180 megawatts. And as I mentioned before, Plant X1, X2, and Cunningham 1 are not currently operational, so we do not include them in our loads and resources table that was included in the IRP.
Isn't SPS also retiring the Maddox 2 unit, or am I mistaken on that?
No, we're requesting to extend Maddox 2 from end of year 2025 to end of year 2028, but we're not requesting abandonment at this stage.
Gotcha. So how many megawatts is Maddox 2?
It's approximately 60 megawatts, 60.
Okay, so just speaking then about the Cunningham unit, the 180 megawatts, you'd agree with me that if SPS's recommended portfolio adds 84 megawatts of dispatchable capacity, and the Cunningham unit is worth 180 megawatts and it's retiring, the expectation is that over the next few years, the amount of dispatchable capacity on SPS's system will decrease.
Based purely on this recommended portfolio, I would agree with you.
Okay. So would you also agree that between now and 2027, SPS is anticipating approximately 400 megawatts of load growth?
I would have to look at the vintage of that forecast, but it is definitely in the several hundred megawatt range.
Okay, so if there's going to be, based on this recommended portfolio and the anticipated retirements, a net loss of dispatchable capacity on SPS's system between now and 2027, that means that SPS needs to put in between now and 2030 more than the minimum 1,043 megawatts that's projected in the IRP filing, correct?
No, I disagree with you. I believe the IRP filing did. Let me just check the vintage. Sorry, there's several of these forecasts. No, I think if we go back to the IRP document and we go back to page 2, if you don't mind if I just read here, the IRP continues the progress SPS has made, which is best demonstrated by SPS's recent application to the Commission for approval to build an additional 418 megawatts of cost-effective new solar generation and the addition of our first battery energy storage resources in the region. So I believe the impact of both the additional resources and the retirements you're mentioning are included within the analysis in the IRP.
Okay, so in that case, the situation is that between the end of this recommended portfolio period and 2030, so in other words, between now and 2030, SPS needs to add a little over 1,000 at the low end megawatts of dispatchable capacity, or up to 4,463, right?
I believe it was 4,290, but yes, in that range, the 1,000 to 4,000 range.
And in SPS's IRP filing, did it detail the amount of dispatchable capacity that it believes is necessary to maintain reliability on its system?
Yes, all of the numbers quoted are based on an economic dispatch of a model that resulted in 0 megawatt hours of of expected unserved energy.
Okay, and that's something that you discuss on page 15 of your rebuttal, right? The expected unserved energy.
Let me just rearrange these folders again, please excuse me. Yes, I'm there.
Okay, so on page 15 of your rebuttal testimony, you state that SPS considers energy adequacy in its planning studies and assigns a very high value to expected unserved energy in its modeling, right?
Correct.
It's fair to say that in this proceeding, you didn't disclose the value of that you assigned to expected unserved energy in your modeling, right?
We were asked that question in discovery, but I do not recall if that was in this case or in the Texas case.
Okay, but it's not in your testimony at a minimum, right?
Not that I recall.
And has SPS disclosed the value that it assigns to expected unserved energy in its planning models to the commission or stakeholders?
The number is within the Encompass output files that we provided in discovery. Again, I know we've answered that question in discovery. I would have to check whether it was in this case or in the Texas case.
Well, thank you, Mr. Elsey. I appreciate your time. No further questions, Your Honor.
Okay, thank you. NMLCG.
Thank you. Good afternoon, Mr. Elsey.
Good afternoon.
I'm Nick Stoffel. I'm one of the attorneys representing the New Mexico Large Customer Group in this proceeding. I would like to have a discussion with you regarding how the proposed battery energy storage system, or BESS, at issue in this proceeding was selected as part of SPS's recommended portfolio. So several years ago, SPS prepared its 2021 Integrated Resource Plan, which identified the future load on SPS's system and the resources needed to reliably serve that load, correct?
It identified the generic resources to serve that load, not individual resources.
And so as part of the resource planning process, SPS not only identifies the resources needed to meet expected load, but also the resources necessary to satisfy a planning reserve margin, correct?
That is correct.
And the planning reserve margin is a minimum level of capacity that exceeds the projected peak load to allow for system contingencies, including generating unit or transmission outages and other uncertainties, right?
That is correct.
Other uncertainties could include customer load growing faster than projected.
Within a reasonable range, it could, yes.
Would you agree that the planning reserve margin provides headroom above the projected peak load?
No, so the planning reserve margin is really meant for short-term contingencies. So as you described, generator outages, transmission outages, and I would phrase my earlier comment is actual load above forecast for the year. It is not supposed to provide headroom for long-term load forecasting.
But it is supposed to provide headroom above the projected peak load, right?
Again, I think if you look at contingencies for actual load in 2023 exceeded forecast. It is not designed to give you headroom for projected load going forward.
So when you are required to meet SPP's planning reserve requirements, it's for an upcoming season, correct?
It is correct, yes.
So it's for a projected load that you're required to meet a planning reserve margin requirement, correct?
For the up and coming summer, not for a long-term forecast.
Would you agree that meeting the planning reserve margin is critical to ensuring system reliability?
I would agree it's just one component of meeting system reliability. It's a minimum criteria we should meet and have to meet by the SPP tariff.
And so SPS is a member of the Southwest Power Pool, or SPP, and the SPP establishes the planning reserve margin applicable to SPS, correct?
Applicable to the entire SPP footprint, including SPS.
The SPP recently increased the planning reserve margin from 12% to 15%, right?
Yes, they did, effective summer of 23.
So based on SPS's evaluation of its future load and current resources in the 2021 IRP, the company determined that it had a need for additional capacity, correct?
I would have to go back to the 21 IRP to see what year we needed additional capacity.
Well, you would agree that as a result of the 2021 IRP, the company issued an all-source RFP, request for proposals, in 2022, right?
After the updates to the 2021 IRP, the initial filing, I do not believe we identified the resource need at that time.
And so you updated the IRP, and based on the updated IRP, as you recall, you had a projected need for new capacity. And so the company issued an all-source RFP in 2022, right?
That is correct, yes.
And by all source, that means it was open to any resource technology, including gas-fired resources and renewable resources, right?
Yes, we did not specify resource types.
So the RFP was not limited to renewable resources that would help SPS comply with New Mexico's renewable portfolio standard, right?
No, it was not.
The SPS solar projects are being proposed solely on capacity grounds, correct?
I mean, the initial intent is to meet SPS's capacity need, but I believe the solar resources provide additional economic energy benefits. They provide additional renewable energy certificates to count towards the New Mexico RPS requirements. They also provide production tax credits to SPS's customers.
So can we look at SPS Exhibit 5? That's your rebuttal testimony at page 15. That's page 21 of the PDF.
Okay, I'm there.
Now I have to get there, one moment. So on lines 6 to 7, you testify, while the SPS solar projects have been proposed solely on capacity grounds. Do you see that?
Correct, yes.
All right, so SPS uses the Encompass production cost model to evaluate the bids in the RFP, right?
Yes.
And that is a commercial power planning model built by a third party, is that right?
It is, yes.
And Encompass is the same production cost model that SPS uses for resource planning, right?
It is, yes.
And the bid evaluation process conducted under the 2022 RFP was overseen by an independent evaluator, is that right?
That's correct. Guidehouse was the independent evaluator.
So based upon the bids received in response to the all-source RFP, SPS created a resource portfolio to address the forecasted capacity need in the most reliable and cost-effective manner, correct?
Yes, the forecasted capacity need as of the spring 2023.
And specifically, SPS relied on Encompass to select the lowest cost bids to meet SPS's entire capacity need through 2027. Is that right?
I would maybe reclassify that to say the lowest cost portfolio of bids, not necessarily the lowest cost individual bid.
And just to make sure we're on the same page, that's because you could have what looks like a low cost bid in isolation that doesn't perform well as part of the portfolio of all the resources. Is that why?
That's correct. And also What we're looking for is the lowest cost to serve our entire system. So for example, adding a very low cost wind project may not provide the energy in the times in which we need it.
So Encompass creates the most cost-effective portfolio of resources that results in the lowest total system cost on a present value of revenue requirements basis. Is that right?
That's correct.
Was that the base case portfolio described in your testimony?
Can you just refer me to the page number for the base case?
Well, so base case shows up on page 31 of your direct testimony. That's page 37 of the PDF. And it's just labeled as Encompass Analysis Summarized Base Case.
So the base case assumed no extensions of existing gas resources and no short-term capacity purchases. So in other words, it assumed we could meet our entire resource need with projects that came through the RFP without taking any alternative actions such as extending the life of a gas unit.
And so this base case was the lowest cost portfolio based on the inputs or the assumptions that Encompass had to work with, right? It couldn't extend the plants.
Correct, yes.
Okay, did that base case include any battery storage resources?
It certainly had a solar project that had the option of a battery. I don't recall if the base case had the battery with that solar project.
So after you got the base case, SPS conducted further qualitative and quantitative reviews of the modeling results to create its recommended portfolio, right?
Correct.
And so like you just mentioned, that included extending retirement dates for certain existing thermal units, right?
Yes.
And also adding incremental battery energy storage, correct?
Yes, it did.
So let's take a look at NMLCG Exhibit 5, which is SPS's response to OPL 10.
Okay, I'm there right now.
And you are the sponsor of this response, correct?
Yes, I am.
I'd move to admit Exhibit NMLCG 5.
Request is to admit NMLCG Exhibit 5 onto the record. Any objection?
Objection, Your Honor.
It is admitted.
So the company discovered that the Encompass model was required to select more costly and lower scoring projects to fulfill a very small capacity need in 2026 before more economical projects were available in 27. Is that right?
I'm sorry, where are you reading from? Are you back to my direct testimony?
Yeah, this is back to your testimony.
Sorry, give me 1 second.
Of course. Page 30.
Okay, can you reread that sentence?
Yeah, so the company discovered that the Encompass model was required to select more costly and lower scoring projects to fulfill a very small capacity need in 2026 before more economical projects were available in 2027, right?
Correct, yes.
So SPS assumed Maddox 2 could be extended through summer 2026, re-optimized Encompass, and determined that it could save customers $43 million on a present value basis through 2042, right?
Yes, that's correct and summarized in table BRE4.
And you agree it's a good thing when SPS can figure out how to meet its system capacity needs at a lower cost, right?
Yes, I do.
Why is that?
Why is it a good thing to serve our customers at lower cost?
Yeah.
I believe that's, one of the pillars of our company is to provide clean, affordable energy to customers.
And the company actually figured out it could lower costs by another $24 million on a present value basis by assuming some additional short-term capacity purchases for a total savings of $64 million from the base case, right?
67 million.
67. And then the company, according to your testimony, also determined that extending Maddox Unit 2 and Cunningham Unit 2 was more favorable than short-term capacity purchases, right?
That's correct. The short-term capacity purchases were somewhat speculative in terms of their availability and cost. Once the separation protocols were no longer in place and we could talk freely within Xcel Energy to other departments, it was determined that we could actually extend the retirement life of Cunningham Unit 2 from the end of 2025 to April 2027, which had the same impact as doing short-term capacity purchases.
And so replacing the short-term capacity purchases with the extension of Cunningham Unit 2, is that shown on Exhibit NMLCG 5, the response to OPL 10?
No, it is not. I believe I described why in my direct testimony.
So this response that says the present value revenue requirement, reserve margin, and EUE for expected unserved energy for all portfolios does not actually show the results for all portfolios.
Well, as I described in my direct testimony, let me just find it. On page 32, do you want me to wait for you to get there?
I'm looking at it, yeah.
Okay. Is SPS proposing to rely upon short-term capacity purchases to meet its capacity need? No, due to the separation protocols that were followed during SPS's evaluation of the RFP, the bid evaluation team was prohibited from discussing its evaluations with members of the energy supply team, including Mr. Lido. In abundance of caution, the bid evaluation team also did not discuss the potential of extending the retirement dates of existing units and using short-term capacity purchases as a placeholder for the purposes of modeling. Once the separation protocols were removed, SPS identified the extension of Maddox Unit 2 by 3 years and the short-term extension of Cunningham Unit 2 as more favorable than the short-term capacity purchases. In other words, the analyses that you see in Exhibit NMLG5 was prior to the separation protocols being removed.
And when it says more favorable in your testimony, is it fair to conclude from that that it was actually a lower net present value of revenue requirements associated with that extension?
We think that it's more likely to be lower cost due to the unavailability or the unknown availability of short-term capacity purchases, and the potential for paying a deficiency payment if we could not get short-term capacity purchases.
Thank you. So even though in the company's view, the shortlisted projects identified from the 2022 RFP provide the lowest cost solution for SPS's requirements under the planning reserve margin, SPS determined that it needed to add additional capacity, right?
Correct, because I think I would maybe rephrase your point there to the minimum PRM requirements.
If we could look at SPS Exhibit 4, page 32.
Okay, I am there.
Oh. never mind, we can move on from that one. So looking at exhibit NMLCG 6.
Okay.
And this is SPS's response to OPL 113. Do you see that?
Yes, I do.
You are the preparer and a sponsor, right?
That's correct. I'm a preparer and a co-sponsor.
I'd move to admit exhibit NMLCG 6.
No objections, Your Honor.
Okay, NMLCG 6 is admitted.
So when SPS decided that the base case with the shortlisted resources was unreliable and it needed additional capacity, that was not because the base case failed to meet or exceed the 15% planning reserve margin, right?
Correct. It met the minimum 15% planning reserve margin. We determined it needed additional capacity for headroom.
And it was not because a portfolio without the SPS selected battery storage projects would have resulted in expected unserved energy, correct?
Not based on the load forecast we evaluated at the time from the spring of 2023.
Adding the 2 battery storage projects to the recommended portfolio increased the present value revenue requirements by $86 million compared to the lowest cost portfolio shown in exhibit NMLCG 5, correct?
Could you give me the number one more time?
So adding the 2 solar projects, essentially comparing base case with Maddox 2 extension and short-term capacity purchases, 14,578,000,000 against the preferred portfolio, 14,659,000,000. That increased cost by $86 million on a present value basis, right?
I believe the preferred portfolio, I'd have to check, also would have included the Cunlum 2 extension. So I don't know offhand how much is attributed to the batteries and how much is attributed to the other changes that were made in the recommended portfolio.
But you agree that that comparison between the portfolios shown here on a net present value of revenue requirements basis, the lowest cost portfolio of 14,578 or 14,578,000,000 compared to the preferred portfolio, 14,659. So the preferred portfolio is more expensive, right?
It is, and it also increases the reserve margin from 15% to 16.28%.
Looking at attachment BRE1 to SPS Exhibit 4, so that's your direct testimony, page 44 of the PDF.
I'm not seeing the PDF pages. Do you mind just giving me the...
So it's SPS Bates number 298, if that's easier.
Okay, yeah.
So just getting to the cover page of the IE report.
Got it.
And that's the IE report that we were talking about earlier, right?
It is, yes.
And if we could turn to page 60 of the PDF, which is page 11 of the report. And looking at the paragraph beginning with as shown on table 5. There it says 4 of the top 5 highest scored projects were selected for the shortlist using the combined bid scoring Encompass modeling approach. The 4th and 6th highest scored bids were for standalone battery storage projects and were not selected by Encompass in any run, indicating lower value from a system portfolio perspective, right?
So just to meet the minimum 15% planning reserve margin, that's correct.
The IE report does not address SPS's creation of the recommended portfolio by adding the standalone storage projects to the shortlist, correct?
I believe that is correct, yes.
Because if we look at the end here, in sum, with the review and approval of the IE, 4 distinct projects were selected for the shortlist, comprised of a total of 418 megawatts of self-build solar capacity and a 230 megawatt of thermal capacity PPA. The IE closely monitored the project scoring process and the selection of the shortlist and approved the selection on May 31st, 2023. This concluded the IE's monitoring of the RFP process, right?
That's correct. Again, to meet the 15% minimum planning reserve margin based on the spring 2023 forecast.
So let's look at Exhibit 5, SPS Exhibit 5, your rebuttal testimony, page 8. That's page 14 of the PDF.
Okay, I'm there.
There you explain that SPS proposed the new battery due to concerns that the solar resources and Borger long-term PPA would provide insufficient headroom beyond SPS's minimum capacity requirements under the planning reserve margin to be able to address the potential for unexpected increase in SPS's load, right?
Yes, I do.
SPS opposed SPP's decision to increase the planning reserve margin from 12% to 15%, correct?
I believe SPS opposed the immediate increase from 12 to 15%. I believe we were amenable to a staggered increase.
SPS actually participated in a complaint against SPP for increasing the planning reserve margin to 15% without staggering that increase, correct?
Yes, that's correct.
And part of why you're saying is it was insufficient headroom was for potential for an unexpected increase in SPS's load, right?
That's correct, yes.
SPS is expecting significant increases in load on its system, correct?
SPS is and was expecting load increases from the spring of 2023. When we released our summer of 2023 load forecast, we actually seen higher load growth than originally projected at the time of evaluating the RFP.
And SPS is planning to issue another RFP in 2024, correct?
That is correct, yes.
Thank you. I have no further questions.
Okay, thank you. Next for cross is LES.
Thank you, Mr. Hearing Examiner. This is Susan Miller on behalf of LES. I do not have any questions for this witness.
Okay, thank you. Department of Justice.
Thank you, Your Honor. This is Jocelyn Barrett on behalf of the NMDOJ, and my questions have also all been covered, so I will waive my cross.
Okay, thank you. CCAE.
Thank you, Hearing Examiner. I only have a few questions.
Okay, proceed.
Okay. Nice to see you again, Mr. Elsey.
And you.
Thank you. I'm just going to be asking you some general questions, mostly to gain insight into some of the resource planning that we are going to be following up on. So I am just wondering generally what criteria makes it a project economic for SPS? What do you consider?
I think there's maybe two interpretations of the term economic. When we have a resource need, so a capacity need in order to maintain system reliability, we're going to issue a request for proposal. And the lowest cost bids in that portfolio will be the most economic ways of meeting that capacity need. If we do not have a capacity need, for example, in the case of Sagamore and Hale, we then may propose resources that are not required to meet capacity, but are intended to lower system costs. We would then refer to those projects as economic.
So in this portfolio of CCNs that you're requesting, which are lowest cost and which are economic?
In this case, we had and we still have a growing capacity need. So it's the former. We chose the lowest cost resources to meet our capacity need.
Okay. And generally, considering SPS's current portfolio, what facilities are currently dispatchable?
In SPS's existing portfolio,
Mm-hmm.
typically
Of all facilities.
Yeah, so if we talk on resource type, our cogeneration, our gas steam generation, our gas combustion turbine generators are all considered dispatchable. Our renewable resources, our wind, our solar resources are considered variable energy resources.
Except for the battery.
We don't have any on the
understanding.
existing portfolio. When we add the battery to the system, that would be considered a dispatchable resource.
Okay. And is it your opinion that renewable sources of energy will, in the foreseeable future be qualified as non-dispatchable resources?
Correct, yes.
Okay. Now, does SPS have any facilities or projects not currently identified as dispatchable that are or could be dispatchable?
Could you maybe ask that question one more time? Sorry.
Yeah, that's okay. Of the current portfolio of facilities or resources that SPS has, are there facilities that are dispatchable that are currently not being used as dispatchable resources?
No.
Okay. Will stored energy at the battery facility be used to serve customers or to be dispatched to the SPP before energy from that facility is sold? Do you know?
Again, say that one more time. I'm sorry.
Will stored energy at the battery facility be used to serve customers or be dispatched to the SPP before energy from that facility is sold? If assuming it gets approved for the BESS project.
So SPP is going to dispatch the resources based on what's most economic. So if it's most economic to use the solar to serve load, or the most economic to use the solar to charge the battery, that's essentially what we're going to do in summary to a complex question.
Would there be a scenario where SPS would choose to sell the energy stored at the battery facility before it serves customers from that battery energy storage source?
Not that I'm aware of. I would have to see specific examples, but at high level, no.
Okay, so another way to think about the battery storage facility would be that SPS will always serve customers, or the energy will be used for dispatch, and then if there's any excess energy, that is only when SPS would consider selling the energy.
Again, I would need to see some specific examples of kind of what you're describing. It's kind of a complex question, but my understanding is, I said earlier, we would first serve customers with the generation, and then if there's generation available above our native load, that would be then sold into the market.
Great. That's a fantastic answer to the question that I was asking. And then my last question for you is, can any of these proposed projects be expanded in the future?
Could you maybe define expanded?
Yeah, could SPS use any of expand upon any of the facilities to generate more needed capacity?
Yes, potentially. The Plant X 1 and 2 solar project, for example, could be coupled with a battery. As an example, it could be coupled with a small gas aeroderivative turbine to maximize the accredited capacity from that site.
Okay. Those are the my questions for you, and I appreciate your time and all of the, added clarity that your answers provided.
Thank you.
Okay, thank you, Ms. Lynch. Mr. Bagacko.
Mr. Hearing Examiner, just a little bit. May I proceed?
Proceed.
Thank you. Mr. Elsey, how are you doing this afternoon?
I'm doing well. How are you, sir?
I am all right. It's good to see you again. I'd like to direct your attention to your direct testimony, SPS Exhibit 4 there at page 34.
Okay, I'm there.
Specifically, I'm looking at lines 9 through 15 there, where in answer to the question, will the additional BESS projects included in the recommended portfolio provide any additional benefits beyond capacity? You discuss in those lines that follow ramping up and ramping down with respect to the BESS project. Is that correct?
That is correct, yes.
Talk about there on lines 13 through 15, you say, furthermore, technical capabilities such as ramping will likely generate ancillary service revenue from the Southwest Power Pool integrated market. Did I recite that correctly?
Yes, you did.
Now, when you use ramping in connection with the BESS project, talking about ancillary services, is that the same thing as, what I understand to be what they call reactive supply or voltage control?
Not quite to voltage supply. What we're essentially talking about is a product where a generator's output can vary over a relatively short space of time. So, for example, it could be outputting 10 megawatts and it could ramp up to an output of 20 megawatts.
And that's reactive supply, or is that just sort of keeping pace with demand?
I refer to it as ramping. It sounds very similar to reactive supply, but I'll be honest with you, I've not seen the definition of reactive supply.
I see. Do you recall in cases past where we talked about torque being turned into a synchronous condenser?
Yes, I do.
And is this then what you're talking about in terms of ramping up and ramping down? Is that similar to the purposes that you put a synchronous condenser to on the system?
In this instance, no, that's not what I'm referring to. I'm referring to the ability for a generator to ramp up or to ramp down to serve load. For example, as renewable energy production drops, the battery can ramp up to meet that load. Mr. Lido could address any voltage stability benefits at the same time.
Okay, well, Thank you for the explanation and clearing up my confusion. That's really all I've got. Not much left. I hope you have a good afternoon.
Thank you.
Thank you.
Okay, that concludes cross-examination. Any redirect, Mr. Lill?
Briefly, Your Honor.
Proceed.
Mr. Elsey, counsel for New Mexico Large Customer Group asked about the purpose of headroom beyond the PRM minimum. And he also asked if the PRM was designed to provide headroom in the event of a generator outage. What happens if a generator goes into forced outage over the winter and it's not expected to come back online until the middle of the summer? How would something like that impact SPS's PRM compliance?
In such a case, we would not be able to count the capacity from that generator towards serving our PRM requirements.
And if you ended up with insufficient accredited capacity under the PRM, what would be the consequence?
We would be forced to pay a deficiency payment to the Southwest Power Pool.
And roughly how much are those deficiency payments?
The deficiency payments on a sliding scale. On the minimum side, it is currently $85.61 per kW year. And as I said, there's a sliding scale, so there's a multiplier up to 2x the deficiency payment, which would come to $171.22 per kW year.
Thank you. Counsel for New Mexico Large Customer Group also asked you whether batteries were needed to meet SPS's PRM requirement, specifically the SPS batteries. Based on SPS's most recent load forecast, are the SPS batteries needed to meet SPS's PRM minimum?
Yes, based on our summer 2023 load forecast, we need the entire recommended portfolio to count towards our capacity need. And even then, we're projecting an actual shortfall of capacity if the batteries are approved.
Additionally, counsel for New Mexico Large Customer Group asked you if the independent or the IE monitored SPS's addition of the SPS battery projects. Did the IE monitor SPS's decision to extend Cunningham 2 and Maddox Unit 2 as part of the recommended portfolio?
No, that was after the independent evaluator concluded their position.
And finally, Ms. Lynch asked you about how the battery will be dispatched. Does SPS currently have any plans to self-dispatch the battery, or will it be bid entirely into the SPP market?
It is my understanding it would be bid entirely into the SPP market.
Thank you. Pass. No further questions, Your Honor.
Your Honor, if I could ask some brief thoughts on that line of redirect we just had there.
Okay. I'll allow the recross on the redirect. Go ahead.
Thank you. Mr. Elsey, will you please look at attachment BRE1, page 16 of 20. That's page 59 of the PDF for Exhibit 4.
Okay, let me just make sure I got that. Exhibit 4, page 59.
Correct. So it's SPS base number 313, if that makes it easier for you to find.
313. Okay, I believe I'm there.
So your counsel just asked if the IE oversaw the decision to extend Maddox 3, and your answer was no. Having refreshed your recollection based on page 10 of the IE report, did the IE oversee the company's decision to extend the life of Maddox and include 25 megawatts of short-term purchases?
Correct me if I'm wrong, but I believe when I answered Mr. Leo, he was referring to Cunningham 2 and Maddox Unit 2. This here in the IE's report is specifically to Maddox 2 and the short-term capacity purchases.
So the IE did oversee the extension of Maddox 2 and the assumption regarding short-term purchases. The IE did not have any involvement in the substitution of the extension of Cunningham 2 for those short-term purchases, correct?
That is correct.
Thank you. That's all. Thank you, Your Honor.
Okay,
No
thank
further
you.
redirect.
Proceed.
Oh, no further redirect, Your Honor.
Okay. With that, the witness is excused. Let me just check the SPS's next witness. Right now I have two parties. Ms. Lynch, is 45 minutes still the requested time for SPS witness Lytall?
No, Your Honor, I don't anticipate having that much time for him. It may be 10 minutes.
Okay, let's take a 10 minute, let's take a quick 5-10 minute break. So SPS can switch out the witnesses. It looks like we will be able to get through witness Lytall. But let's take a quick break and come back at 4:15 for the next witness. And then we should be able to, that'll probably be our last witness for today. Okay, I have 4:15 on my phone. Let's get everyone back. Madam Court Reporter, let's go back on the record.
Yes, sir.
And SPS, go ahead and call your next witness.
SPS calls Mark Lytle. Mr.
Mr.
Lytle, we,
Excuse me, man, swear, sir. Sir, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Lytle, can you please state your name for the record?
Mark Lytle.
And in front of you should be what's marked as XPS exhibit number 7. And that's a copy of your direct testimony, correct?
Yes, sir.
Are those answers in your testimony the same? Would they be the same today if you were asked those questions live?
Yes, sir.
With that, I tender the witness.
Okay, thank you. CCAE.
Thank you. Hi, Mr. Lytle. I'm the attorney for the Coalition for Clean Affordable Energy. It's good to see you.
Good to see you.
I just have one question about the water source that will be used for or that is used for the proposed extension of service life here. This is referring to Cunningham and Maddox.
Okay.
What is the source for Cunningham?
Groundwater is used for their water source at Cunningham.
And where does that groundwater come from?
An underground aquifer there.
Do you know the actual name of the aquifer?
I'm assuming it's the Ogallala aquifer.
Okay. And would that be the same for Maddox?
Yes, ma'am.
Okay. And in your capacity, could the proposed projects have been expanded to help SPS meet growing capacity needs?
Which projects are you referring to?
The ones proposed here, the solar and the battery, could the energy output or the megawatts being proposed have been more than what are being proposed now?
Not at this time. These are replacement projects. So we have to go back in with the same megawatt rating as the units we're retiring. So we could not have added additional capacity in this replacement filing. In the future, we can add on to these, but we would have to secure new transmission rights through the diocese process with SPP to expand those, but it is a possibility in the future.
Okay, those are my questions. I know they were not many. I'm sorry if they are the only ones, but I appreciate your time, and maybe staff has more. Thank you.
All right, thank you.
Okay, Mr. Bagacko.
Mr. Hearing Examiner, thank you. Mr. Lytle, thank you for your attendance today.
You bet.
I note there on SPS Exhibit 7, your direct testimony on pages 3 and 4, you talk about having testified before regulatory authorities. Do you see that starting down there on line 16 on page 3 and running through line 7 on page 4?
Yes, sir.
And I understand this testimony was filed a while back. So it may not be perfectly up to date, but can you tell us whether or not you are serving as a witness in the CCN proceeding in Texas by SPS that regards some of the same resources under consideration now in this proceeding?
Yes, sir, I am.
And what testimony have you filed in that case?
It's very similar to what's in this New Mexico filing.
So you've done some direct and some rebuttal, I take it by now?
I have, yes. In Texas, I did file rebuttal.
And I don't mean to put you on the spot, but can you tell us the docket number for that proceeding before the Texas PUC?
No, sir, not right off. It's, I don't know that right off.
Okay, all right. But the testimony you have filed in that proceeding then is obviously subsequent to what I see here in your direct testimony filed as SPS Exhibit 7, correct?
That's correct.
Well, thank you for that. I don't want to take any more of your time. And like I said before, thank you for participating in this case, Mr. Lytle. I pass the witness, Mr. Hearing Examiner. Thank you.
Thank you, sir.
No redirect, Your Honor.
Okay, with no redirect, the witness is excused.
Thank you, sir.
For SPS's next witness, I have an hour and a half requested for cross-examination time, which means we will not be able to fit, I highly doubt we're going to be able to fit him into 40 minutes. Let me just quickly review with the parties. OPL, you requested 20 minutes. Is that correct?
That's correct, Your Honor. I figure I could be done in 7 to 10.
Okay. NMLCG, 20 minutes.
Yeah, we requested 20. I think we'll be closer to that 10 range as well.
Okay. LES requested 10 minutes.
Yes, Mr. Hearing Examiner, I don't think I'm going to have up to 10 minutes. If anything, I may have 5.
Okay, well, let's start and see where we end up then, because it sounds like we might be able to do this. SPS, can you call, is your next witness available?
Your Honor, this is Patrick Leahy with Baker Botson. I'm with SPS. We may need 2 minutes to get the witness in the room, but we're ready for his testimony.
Sure.
If you don't mind giving us perhaps a 2 to 3 minute recess to allow him to get in the room.
Sure. If anyone needs that recess, we'll resume at 4:26-ish here.
Thank you, Your Honor.
Okay, I have 426. Madam Court Reporter, let's go back on the record.
Yes, sir.
SPS, go ahead and call your next witness.
Thank you, Mr. Hearings Examiner. SPS calls Ian Fetters.
Mr. Fetters, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Fetters, could you please state your name for the record?
My name is Ian Fetters.
Mr. Fetters, in front of you should be what's been previously marked and previously admitted as SPS Exhibits 8 and 9. Do you see those?
Yes, I do.
Those should be copies of your direct testimony and your rebuttal testimony.
Yes.
Are those documents the same testimony that you would give if you were giving it live today?
Yes, they are.
Your Honor, SPS tenders the witness.
Okay, thank you. OPL, you are first.
Yes, Your Honor. Good afternoon, Mr. Fetters. How are you today?
I'm good. How are you?
I'm doing pretty well. So I wanted to start by talking about some questions that Ms. Trammell deferred to you earlier. And
Sure.
specifically, that was some questions on whether the tax credits that offset the revenue requirement of these projects are expected to fully offset the revenue requirement of the facilities. So you addressed that actually in your direct testimony, correct?
Yes, I do.
And in your direct testimony on page 27, lines 12 to 18, and let me know when you're there.
I'm there.
So on that page, you explain that the projected revenue requirement for these facilities is $36 million.
That's right.
And the tax credits that are expected to flow through to customers are $18.6 million each year.
That's right. After grossing up for income taxes and accounting for transfer costs. That's correct.
Okay, so you agree and you state here that the net increase in rates for the SPS solar projects and the SPS battery project is approximately $17.4 million.
That's correct for that 2028 example in that testimony.
Okay, so given that the revenue requirement for these projects exceeds the projected tax savings that would flow through to customers, you'd agree with me that if these projects go into rates sooner, that means that customers' rates would go up sooner, right?
Yes, that's correct.
Okay, so Mr. Fetters, I want to talk about deferred tax assets. So SPS currently uses a deferred tax asset for its Hale and Sagamore facilities, right?
That's right.
And SPS recovers a return at its weighted average cost of capital on those deferred tax assets, right?
That's right. There are some provisions within the agreement on those Hale and Sagamore projects for how long we would recover on the deferred tax asset. But yes, at this time they are in rates and are being recovered at SPS's WACC.
Okay, and something, could you turn to page 13 of your rebuttal testimony?
I'm there.
Okay, so starting on line 13 of that page, you state that before the passage of the IRA, transferability wasn't an option, and that's transferability of tax benefits, right?
That's right.
And you continue, accordingly, the existing DTA associated with the Hale and Sagamore wind generating facilities is presently included in SPS's rate base, earning a return on SPS's weighted average cost of capital. Is that right?
That's right. And the Inflation Reduction Act does not allow for transferring any PTCs generated prior to the beginning of 2023. And so we continue to be unable to transfer the majority of the DTA that is present at this time for those units.
Okay, but you would agree with me that now that transferability of those tax credits is an option, it makes economic sense for SPS to transfer them rather than accumulating them in a DTA, right?
Yes, as I talk about in my rebuttal testimony, transferring the PTCs upfront to the extent that SPS cannot use the tax credits to reduce its own tax liability is a net savings for the customers relative to continuing to have a deferred tax asset and rate base.
So in fact, on page 15 of your rebuttal testimony, you state that it wouldn't just be a benefit to customers. On line 11 and 12 of your rebuttal, you state that it would be overwhelmingly beneficial to customers to transfer PTCs rather than let them accumulate in a DTA, correct?
That's right, because the transfer cost would be a one-time occurrence, whereas the DTA, assuming that SPS is unable to use those PTCs, would remain in rates for several years, potentially until SPS has the ability to use those PTCs.
Okay, would you agree with me that all else equal, SPS would have a greater incentive to transfer tax credits if it did not have the option of recording them in a deferred tax asset and recovering a return on that asset at its weighted average cost of capital?
Could you repeat the question? I'm sorry.
Sure. Would you agree with me that all else equal, SPS would have a greater incentive to transfer tax credits if it did not have the option of recording them in a deferred tax asset and recovering a return on that asset at its weighted average cost of capital?
I don't think so. I think one of the primary benefits of transferring the PTCs is reducing the DTA and the overall cost to customers. And so I think that is one of the sort of major driving factors of transferring PTCs.
Well, exactly. So it's beneficial to customers to transfer the PTCs out, right? Is what you're saying?
That's right.
Okay, so I want to talk about the financial incentive to SPS. So assume with me that there's two worlds, right? World A, SPS has an option. They either transfer the PTCs or they put them in a DTA and get recovery at their WACC. So that's world A. Are you with me there?
I believe I'm following.
Okay, and in world B, SPS has the option between transferring the PTCs or they do not get any recovery on them if they're unable to transfer them. Are you with me on that?
Yes.
Okay, so world A, where SPS has the option to get their weighted average cost of capital if they're unable to transfer, that's more attractive to SPS from a financial perspective, right? Because they have the option to get their WACC if they fail to transfer the PTCs, right?
Yes, I think SPS would prefer to earn a WACC on the DTA if it is unable to be used or sold or transferred.
Okay. So when SPS was modeling this, these proposed facilities and putting together its CCN application, SPS assumed that it would be able to transfer all of the unused tax credits, right?
That's right.
Okay, and on balance, that assumption would decrease the cost, the projected cost of the facilities and make the CCN look more attractive, right?
I think overall, being able to transfer all of the PTCs would result in a sort of lower overall revenue requirement for the customers than if the DTA were to accumulate over time. But I also believe that that lines up with what we expect to actually occur. We, as Ms. Trammell testified earlier, there is a large demand for these PTCs that SPS and Xcel Energy as a whole has seen since the passage of the Inflation Reduction Act. And we discuss in our testimony that one of the considerations there just overall is looking at the cost to the customers and seeing how beneficial it would be to transfer the PTCs versus letting them accumulate in the DTA. And so all of those considerations lead towards we would transfer as many of the PTCs as possible. And that is the sort of best assumption of what the world is going to look like when these projects are placed into service.
Gotcha. So going back through that to pick out what I think the answer was, you agreed with me that that on balance, assuming that you'd be able to transfer all of the tax credits, that would reduce the projected revenue requirement for the proposed facilities, right?
That's right.
Okay, and SPS did make that assumption.
Yes.
Okay, but having or allowing a SPS to record untransferred tax credits in a DTA and recover a return on that effectively insulates SPS against the possibility that it's unable to transfer all of the tax credits, right?
I think it's a matter of just sort of matching the costs of the PTCs with the benefits of the PTCs that are given to customers. When the PTCs are generated for these projects, we pass back we credit the value of the PTCs in their entirety to customers through the fuel clause, and we're proposing to do that in this case with the solar and battery projects. But to the extent that SPS is unable to use those PTCs to reduce its own tax liability, or going forward unable to transfer those PTCs will accumulate in a deferred tax asset that just sits on the books. And so including a return on that deferred tax asset in rates would be sort of commensurate with passing the PTCs back to customers.
Okay, but back to my question though, allowing SPS to get a return on that deferred tax asset, it would insulate SPS financially against the prospect that they would not be able to transfer unused PTCs, right?
I think we The proposal to include the deferred tax asset and a return on the deferred tax asset through fuel in this case is somewhat of a sort of fail-safe overall to the possibility of not being able to use or sell or transfer all of the tax credits. That is, as we've said several times, our intention to sell or transfer any tax credits that we can't use, and we do anticipate that to be the case. But to the extent that we're unable to, that DTA is sort of a matching of the cost of those PTCs still being on SPS's books.
Okay. Well, I think that that answers my question. And thank you for your time. Nothing further for this witness, Your Honor.
Thank you.
Okay, thank you. NMLCG.
Thank you. Good afternoon, Mr. Fetters. I'm Nick Stoffel. I'm one of the lawyers for the New Mexico Large Customer Group in this proceeding.
Good afternoon.
So Mr. McMillan just made my job easier, so I just have a couple questions for you. And so that's, as you just covered, right, the company assumed that it would be able to transfer all of the tax credits for its modeling in this proceeding, correct?
That's correct.
And the company continues to believe that's a valid assumption and that you will be able to transfer all of the tax credits associated with the solar and battery storage facility proposed in this proceeding, correct?
That's correct.
But the company is unwilling to make that same assumption for rate making. Is that right?
I don't think those two things are necessarily one-to-one. The modeling in this case does represent our best anticipation of what the tax credit situation will look like going forward. We do believe we would be able to transfer or sell all of the PTCs that we are unable to use, and there is a lot of there are a lot of reasons for that. But to the extent that we are unable to do that, there may be, if there are some PTCs that are unable to be transferred in, say, any given year, a DTA would potentially accumulate on those PTCs.
So what you're saying is, if the company's assumptions that you made for modeling and that you currently believe are accurate going forward do not hold true, you are unwilling to agree to those same assumptions for rate making, correct?
I think that a model, and particularly a forward-looking model such as this, is a model. It represents our best forecast of what the world is going to look like, and to the extent we can put in the best possible information, we will absolutely do that, and that's what we've done here. But models are models. There are naturally going to be some fluctuations against what we have put in models. Perhaps costs come in costs for the projects could come in lower than what we have anticipated in this case, at which point the overall revenue requirement for the project would be a little bit lower. In this particular instance, we believe that the company will be able to sell or transfer all of the PTCs, but to the extent that that does not occur, a DTA would be generated, and so it would be appropriate to recover a return on that DTA. So while our model was set up to sort of represent our best understanding of all of the costs and all of the benefits that go into this project, there are natural fluctuations to that.
And the company made the decision not to model a scenario where these tax credits accumulated in a deferred tax asset with a carrying cost at the company's weighted average cost of capital, correct?
I don't think it would have been appropriate to model
My question was whether or not the company made that modeling, sir. Did the company model these projects in a scenario where a deferred tax asset with a carrying cost at the company's weighted average cost of capital accrued for tax credits you were unable to transfer?
I think the model we have in this case does allow for that provision. It just does not have a deferred tax asset in there because the model showed that all of the PTCs would be sold or transferred.
So my question that you are not answering is, did SPS run a model that assumed the existence of deferred tax assets with a carrying cost at the company's weighted average cost of capital for the projects proposed in this proceeding?
No, it did not develop a model that shows a DTA accumulating.
And the company is not willing to make that same assumption for rate making in this proceeding based on the request in the application, correct?
Your Honor, I object. This last question here, he asked.
Basis of the objection, please.
Sure, Your Honor. This last question here, he asked previously, and I believe the witness answered.
And Your Honor, I've asked this question twice and I've gotten evasive answers. I have not gotten an answer about whether the company will make the same assumption for rate making in this proceeding.
And Your Honor, the witness has given it. Go ahead. I'm sorry.
To the extent I agree that the first part of the question has been asked and answered. To the extent that we have yet to hear a direct answer as to whether the same modeling will or will not occur in the rate making, I will allow the witness to answer.
Mr. Fetters.
And would direct him to answer with an affirmative yes or no before clarifying the answer.
Mr. Fetters, do you need me to repeat the question?
One more time, please.
For modeling, the company assumed that it would be able to monetize all of the tax credits associated with the projects in this proceeding. The company continues to believe that assumption is accurate and there is demand for those tax credits. But the company is not willing to make that same assumption for purposes of rate making, correct?
Your Honor, I have to object to the question again. It assumes facts and not an evidence. I don't know the source of the supposed assumption about what the company may or may not do in the future. I mean, he's stated essentially that the company will refuse or otherwise not do something, and I'm not sure of the source of that.
Okay, to the extent that the answer requires him to say the company, certainly that is categorized by that being his opinion. So I'm going to allow him to answer.
The For rate making purposes, no, I don't think the company would want to assume the entire absence of a DTA.
Thank you, Mr. Fetters. I have no further questions.
Thank you.
Okay. We have 8 minutes left before 5 o'clock. LES, are you going to be able to fit your questions in?
Yes, Mr. Hearing Examiner, my questions have already been asked, so I don't have anything further for this witness. Thank you.
Okay, thank you. All right. The next request for cross-examinations by Department of Justice, they requested half an hour. I think this is going to be a good stopping point for today. So SPS and Mr. Fetters, make yourself available and we will resume tomorrow morning at 9 o'clock to finish cross-examination by New Mexico Attorney General and staff. And Mr. Leahy will be allowed, of course, redirect at that time. But I think for purposes of timing, this is a good stopping point for today. Quick little bit of housekeeping as well. Let me see. Miss Hardy, there you are. We were talking about the confidential submission for Mr. Bornhoff, and I reviewed my email, and my office did receive the physical copy of that. I had written an email back on January 10th asking if I could see a digital version or something to that extent. I don't believe I received a response. So if you could make that available to me, either through a digital watermarked copy, or if you prefer putting that into, a Dropbox with a pass protected Dropbox, I'll leave that to you and the preference of your client, how you would like to allow me to review that digitally. But I don't believe even though the office back in Santa Fe did receive the physical copy, I just like to be able to look at the digital version of that. So
Sure.
if you can arrange that, I would appreciate it. And then I can I'll do the determination on that after I review it. But for purposes of tomorrow morning, we'll continue with witness Fetters for the last 2 rounds of cross-examination and then proceed with the other witnesses. I think we should still be able to get it done by the morning session. So to that extent, we actually did fairly good getting everything in today. So with that, Madam Court Reporter, do you have any questions from today's proceedings?
I do not. Thank you, Mr. Hearing Examiner.
Okay.
Mr. Examiner.
I'm sorry, I missed you, Miss Hardy.
Yes, thank you. I did want to mention that SPS is evaluating its cross-examination plans for tomorrow, and we may have some changes. There may be people we don't need to cross, or we may be able to reduce our times. So we will let you know this evening.
Okay, that'll be fine. Thank you.
Thank you. And Mr. Examiner, one other issue is SPS had requested an expedited transcript of this matter. And I believe we need Your Honor's approval to obtain that, and we hadn't officially asked you. So I wanted to mention that to make sure the court reporter was aware.
Yeah, that is something that we need to arrange well in advance with our court reporters. And, I believe I had asked if final action by the commission, let me just pull this up.
And Mr. Examiner, it's my understanding that we did advise Ms. Kippenbrock on January 28th of our request, or 29th of our request for an expedited transcript.
Okay, give me 1 second. Okay. To the extent that I issued the order requiring status update response back on the 30th of January. And I believe yeah, there it is. You filed the response indicating that the final order by the May 16th, 2024 open meeting is sufficient. I do not feel that we really needed a timeline for an expedited transcript, considering the timeline, as long as we get this done by May 16th. So in that regard, I'm basically denying the request for an expedited transcript. I think we'll be able to set timelines tomorrow for briefing and final decision by the commission that's going to fit well within that timeline to get it decided by May 16th without the need for the expedited transcript.
Okay, thank you, Your Honor.
Anything else before we adjourn for today? Hearing nothing, we are adjourned and off the record. Thank you, everybody.
Thank you.
Thank you. Have a good